Welcome to the Cato Institute. Everybody joining us online, everybody here in person. My name is Neil McCluskey. I'm the director of the Center for Educational Freedom here at the Cato Institute. If you're joining us online, I'll just let you know right ahead of time that throughout the conference, if you have questions or comments that you want to make while you're online, if you're using a platform like X, you can use hashtag Cato Events. If you're on other platforms, there are lots of ways to deliver us questions and comments, and you'll see them on those platforms. Now, 100 years ago comes Sunday, so this coming Sunday, the U.S. Supreme Court handed down one of its most famous decisions, Pierce v. Society of Sisters, that struck down an Oregon law that required children to attend public schools in order to fulfill their compulsory education requirements. That decision famously said, quote, "The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations." This case actually came 2 years after another case called Meyer v. Nebraska, which struck down a law that prohibited teaching children in a language other than English in school through 8th grade. That decision said, quote, "Corresponding to the right of control, it is the natural duty of the parent to give his children education suitable to their station in life." So both cases indicated that parents have a right to make decisions for their children, particularly in education. But such a right, I think, perhaps arguably, we'll find out today, extends far beyond education, and we'll probably debate even the extent to which it applies to education, but it almost certainly, or at least arguably, applies to health care and lots of other decisions that are made for children. But this right, parental rights, are not treated as absolute. For instance, in the Pierce decision, it also said, quote, "No question is raised concerning the power of the state reasonably to regulate all schools, to inspect, supervise, and examine them, their teachers and pupils, to require that all children of proper age attend some school, that teachers shall be good moral character and patriotic disposition, that certain studies plainly essential to good citizenship must be taught, and that nothing be taught which is manifestly inimical to the public welfare." So that was a lot, but it lays out all sorts of things that they say actually limit parental rights. So the assertion of parental rights, though, I think became particularly energetic, maybe we could say, with the onset of the COVID-19 pandemic. I at least don't recall hearing a lot of invocation of parental rights until that occurred. And you had lots of debate, of course, about whether or not parents or schools should decide whether or not children are masked in school, whether or not they're required to have vaccinations to attend school, and lots of other conflicts that brought parents and schools into opposition. And then it became more intense, I think, as we started to debate, quote unquote, woke content in schools about race, about gender, and about a lot of other issues. So parental rights may arguably be a bigger issue now than it was a century ago. So what we're going to discuss today are such important questions as: what are parental rights? Do parents have unlimited rights to make decisions for their children? What about children's rights? What if those rights clash? And what is, very importantly, the role of government? So we'll discuss all these questions, I hope and I expect, in the coming panel discussions and our conversation at the end of the conference with Representative Virginia Foxx. These are just important, I think, these questions now, if not more so, than they were at the time of Pierce. Now, I want to give a quick acknowledgement, lest people think this conference was entirely my idea, because it wasn't. A big part of the inspiration, actually, for this event was a symposium I attended in 2024, sponsored by the Classical Liberal Institute at NYU, when we discussed Meyer and Pierce. Meyer was 1923, Pierce 1925. They very smartly made it 2024 to get the 100 split for those two cases. A couple of our panelists, so Professor Dwyer and Michael Bindus at IJ, also participated. And I'll let you know that the papers from that symposium are available at the Journal of Contemporary Legal Issues in their current edition. Unfortunately, it's an all-online journal, so we don't have paper copies for those attending here. But all of those articles, I believe, are open access. So if you really want to dive deeper, even than we get here, I would encourage you to go to the Journal of Contemporary Legal Issues. So thank you again to audience and participants for being here. And now I'll introduce our first panel. It's parental rights. What do they include? Where do they end? To be moderated by Cato's own Tommy Berry. Tommy directs Cato's Robert A. Levy Center for Constitutional Studies. I won't belabor his bio at all. You can find him on Cato's website if you want to learn a lot more about him. But to suffice it to say, Tommy knows a lot about the Constitution, and that's probably going to be pretty important in the upcoming discussion. So with that, I invite the first panel to come up.
Well, thank you so much for that introduction, Neil. Excited to be doing this. So as you said, we have two of the first two panels today. This is the more broad one, the more whole scope of parental rights. And I think a few things just to set the stage of what do we talk about when we're talking about parental rights. When we talk about rights, we can mean, philosophically speaking, what moral rights should parents have. We can talk about constitutional rights, so we might mean what's the right interpretation of the Constitution? Does it enshrine parental rights? Were certain Supreme Court decisions right or wrong? If it does enshrine parental rights, where do they come from in the Constitution? So the discussion might touch on that, but not everyone on this panel is lawyers. So it might also just be a public policy question. Rights could mean what should policymakers enshrine as parental rights. And I think another thing that this discussion may well get into is what about children's rights? And is there any potential conflict between those two? When we're speaking about parental rights, are we assuming that the rights of parents and children always align? So those are just some of the interesting topics and important lines of debate that I hope we'll be able to get into. Just a note for Q&A, I hope many people are watching online, and they should know that they can join the conversation and submit questions at any point during this conversation directly on the event webpage, on Facebook, on YouTube, or on X at #CatoEvents. With that, I'll get into introducing our panel. Starting at the far end, James Dwyer is the Cabell Research Professor and Professor of Law at William & Mary Law School, where he was just recently awarded a 2025 Guggenheim Fellowship. Among his areas of specialization, particularly relevant to this panel, are family law, children in the law, adoption law, and education law. He's written several books, including Homeschooling, The History and Philosophy of a Controversial Practice. And I should note at this point that I was homeschooled most of my K through 12, so I'm particularly interested in discussing that. He's authored dozens of academic articles, including Mired in Meyer's Mischief, a century after the invention of constitutional parents' rights. And outside of the academy, I'm told by a reliable source and William & Mary Law School grad that James is also an accomplished actor who appears regularly on stage in the Williamsburg area, including a memorable turn as Mr. Darcy in Pride and Prejudice. Next up, Melissa Moskela is Professor of the Practice in Philosophy at the University of Notre Dame's McGrath Institute for Church Life. Her work spans the field of ethics, political philosophy, and law, and her areas of special expertise include natural law theory, biomedical ethics, and the family, especially parental rights. She's the author of the books To Whom Do Children Belong? Parental Rights, Civic Education, and Children's Autonomy, and, second book, Ethics, Politics, and Natural Law, Principles for Human Flourishing. Before coming to Notre Dame, Melissa was Associate Professor of Philosophy at the Catholic University of America, right here in Washington, D.C. And finally, Tiffany Justice is a visiting fellow in parental rights at the Heritage Foundation. At Heritage, she spearheads their new Parental Rights Initiative, which supports public policy reforms that strengthen parental authority to direct the upbringing, education, and care of their children. A wife and mom of 4 school-aged children, Tiffany began serving in 2016 on the board for the School District of Indian River County, Florida. In 2021, she co-founded Moms for Liberty, a parental rights group in Florida that has since grown to more than 130,000 members and 300 chapters nationwide. So each panelist will start with just a brief 5-minute or so opening remarks to get the conversation started. We'll start with James.
Thank you, Tommy. Good morning. Whenever you have a public discussion that has parents' rights in the titles, you expect a very contentious discussion, unless one invites only like-minded people. So kudos to Cato for assembling a diverse group of people. I do think that much of the disagreement stems from confusion about concepts and terms, and we might find that we actually agree about much more than might at first appear if we clarify certain things. Being a philosopher as well as a lawyer, I want to start by trying to clarify some concepts that might help make the rest of the discussion more on point. And the first distinction I would draw is between rights and authority. So authority is decision-making power, and people can have that without being entitled to it. So to say that parents have a right is to suggest that they have an entitlement for their own sake, based on their own interests, in having authority and power over children's lives. But we could instead talk about parents having authority gratuitously. It could be just a matter of policy that we think that's the right place to repose authority over child rearing, or we might say that children have a right to their parents having a certain degree of authority as opposed to the state. And a second distinction would be among types of rights. So Tommy alluded to the distinction between legal rights and moral rights. And I think we're mostly going to talk about legal rights today. Even within that category, you have constitutional rights, but then also state-created rights by statute or common law. And some confusion about the history of parents' rights arises from failing to make that distinction. In the 19th century, you see a lot of references to parental authority and power, occasionally to parents' rights, but it was more state-conferred rights. So the idea was that the state has chosen to give parents certain authority over children. Pierce and Meyer were really game-changing in suggesting that in the federal Constitution there was some kind of entitlement on the part of parents to force the state to confer that kind of authority. So they were novel in that respect, and one might go back and examine those decisions and see, is there some argument for that conclusion? And my own view is that you won't find one there. And in particular, this statement that Neil referred to about the coupling of rights and duties, I think is hard to make any sense of. There's no clear syllogism in there. There's a leading of distinctions among types of duties as well as types of rights, and how they're connected is really mysterious. So we can talk more about that. And then the final distinction I might make is between what rights protect. So rights can protect our choices, and that's mostly what we adults have. But rights can also protect people's interests independently of their choices, and so it's coherent to speak of an infant having rights, and I think that's pretty uncontroversial. A 2-year-old has a right not to be kicked, right, because they have an interest in not being kicked, not because they've chosen not to be kicked. And so we can even speak coherently of children having a right that their parents have a certain authority over their lives instead of the state, because that is best for the children, because they have important interests that are protected by reposing authority in the parents. So we could reframe this meeting as being about parental authority, or even as being about children's rights in connection with education. And I think I've exhausted my 5-minute opening, and happy to stop there.
Awesome, very succinct. Melissa?
Great. Well, thank you so much. It's a pleasure to be on the panel, and also kudos to Cato for having a diverse panel. I think it's going to be a really interesting discussion. So in my view, at the foundational level, parents' rights are about parents' authority to make decisions about what's in the best interests of their children. And I do think that that's the basis of a right, namely a right against the state, that the state not encroach on the prior authority of the parents in this arena. Now, someone has to have authority over children. That's not controversial, because children aren't mature enough to make decisions on their own. And psychological and neurobiological evidence show that this is true even in the teen years. So the fundamental question really is, who has primary authority to make decisions on behalf of children? Is it parents or the state? And I have a whole book about this, but the short answer, I think, is that primary child-rearing responsibility and authority belong to parents because they, not the state, have a uniquely intimate relationship with their children, a relationship that, in the central case of biological parents, is literally the very source of the existence and identity of those children. This intimate relationship grounds parents' obligation to care for their children and makes them uniquely suited for this task in terms of knowledge, motivation, and alignment of interests. And because caring for children requires making decisions on their behalf and setting parameters for the child's own decision-making as the child matures, parents' child-rearing duties are the basis of their natural child-rearing authority. This is the core of the natural law argument for parents' rights, and we see it echoed in the common law tradition. Prominent figures like Locke, Blackstone, and in the American context, Kent and Story. Now, to borrow a metaphor from Thomas Aquinas, a precursor to this common law tradition, it's just as natural for children to be raised to maturity within the quote-unquote spiritual womb of the family under the authority and care of their parents as it is for children to be gestated in the physical womb of their mothers. And like that physical womb, and in continuity with it, the family is a kind of spiritual womb, a protected sphere within which children can grow to maturity. And so the family is a natural authority structure that corresponds to unchanging features of human nature and deep human needs, especially, I think, the needs of children. So I'll agree that children's rights are really important. But I think Jim and I are going to differ on what structure best protects those rights. I think the best protection for those rights is to ensure the primacy of parents' educational authority because of that unique relationship that they have with their children. The state didn't create the natural authority structure of the family or the relationship between parents and children any more than it created a woman's womb. And so it's not from the state that parents get their authority, on my view. Adoption, by the way, is the exception that proves the rule here. Because adoptive parents lack that pre-existing relationship with their children, they are vetted and licensed by the state. And as a prospective adoptive parent myself, I can tell you this is an extremely rigorous, invasive process. And adoptive parents also have to make an explicit commitment to take on the duties that biological parents have simply by nature. But once they do take on that commitment, they have the same rights and duties as any other parent. So in my view, this spiritual womb of the family marks out a kind of sphere of jurisdiction within which parents have the authority to direct the internal affairs of the family community, especially the education of children. Of course, children are also under the authority of the state, but parental and state authority over children is not on the same plane. Instead, children belong first and foremost to, and are first and foremost under the authority of, their families. And so their relationship to the state is typically mediated through the family. Now, there are cases in which coercive state intervention into that sphere of authority of the family is justified. But I think those justifications are really similar to the accepted justifications for intervention into the affairs of a different sovereign nation. For instance, to stop abuse or neglect, non-ideologically defined, or to prevent very serious harm to the public order. So if somebody wanted to set up a terrorist training school for their children, well, the state could clearly shut that down. Or if somebody said, I don't want to even teach my children basic reading or basic numeracy, well, the state could say no. There's an important public interest in having citizens with a basic knowledge of academic skills and knowledge of the law, and that can be enforced. And we see, again, this view echoed in the common law tradition with people like Story, indicating that the state shouldn't interfere with the natural authority of parents unless parents are proven guilty of, quote, gross misconduct. And state courts throughout the 19th century echoed this language. Now, of course, parents' rights are not absolute, but because they're so fundamental, a high bar needs to be met before the government is justified in overriding them. And I think that high bar is effectively captured by the legal strict scrutiny standard, which requires that there be a compelling state interest and that the law or policy be the least restrictive means to that compelling interest. And I think that there's strong historical warrant, both in Meyer and in Pierce, and also in these pre-Meyer parental rights cases that were decided on the basis of common law for the use of this strict scrutiny standard. Now, of course, all these cases predated the tiers of scrutiny doctrine that's currently being used in the courts. But as I argue in a couple of recent articles, an analysis of the reasoning in these cases reveals that they were, in fact, applying a heightened level of scrutiny. They were putting the burden of proof on the state. They were requiring that the state prove that the policy was the least restrictive means to the state's interest. And because the state couldn't meet that burden, the parents were winning in these cases. So I don't have time to go into the details here, and perhaps we can get into that in the discussion, but I will just note that in these state Supreme Court cases prior to Meyer, there were 8 of these in which parents wanted to opt their kids out of various aspects of the public school curriculum, generally non-controversial things, singing classes, bookkeeping classes, random things for various reasons. And the parents won 7 out of 8 of these cases in state Supreme Courts on the basis of common law. And these were around the era of the ratification of the 14th Amendment, so they give us a sense of the original meaning of that amendment, and that parents' rights were part of it. And I think that we have to read Pierce in light of these prior cases and in light of the common law doctrine that I think Pierce was effectively declaring to be part of the liberty protected by the 14th Amendment.
Great, thank you. Tiffany?
Good morning. Thank you, first of all, for Cato and Neil for having me here today. I so appreciate the opportunity to have a mom, and not a lawyer, right, but a mom, come and talk about parental rights. So I'm going to disagree with Jim a little bit. I think we're going to talk about legal rights today, but I also think we're going to talk about moral rights, because certainly there is quite a history in the history of mankind of parents having authority over their children. I'm a mom of 4 children, pregnant for 9 months with each of them, breastfed them each for 12 months after that. And the idea that a government official, that a bureaucrat, could rename my child while they are at school, call them by different pronouns, drive a wedge between the relationship with the parent and the child, is absolutely ludicrous. And that is where we currently are in the United States of America. We have government schools, public schools, which are government schools, that are saying to children, you're safe here. Home isn't affirming you, right? We have gender ideology that has captured the United States, and we'll call you by a different name. What name would you like us to use when we talk to your parents? Does anyone question the right of a parent to name your child? Parents have the fundamental right to direct the upbringing of their children, given to them by God, not by the government. Does anyone question, after you have that baby, your right to give a name to that child? Certainly God told us to name things, told Adam to name things. And so the idea that the government now is stepping in on something so simple as the name of your child, that we think that somehow the United States has a role in taking the child away from the parent, like in Colorado, a new law passed that says that it would be coercion, that you could lose custody of your child. It's abusive to not affirm their want of changing their gender. I don't know about you, but my 12-year-old would probably eat Oreos all day long if I let him, right? And so we are in a very, very interesting place in America where something so simple as the right of the parent to direct the upbringing of the child, not only the right, but the duty, you're commanded by God to raise your children, it is under question. And we can talk about the case history, but the fact that, the Supreme Court's going to rule on Mahmoud v. Taylor, this opt-out case, I'm sure we'll talk about that today. And I was talking to a friend, and I said, well, what will the outcome mean? And the truth of the matter is, will the decision of the Supreme Court actually affect what the majority of American parents know in their hearts, their belief and their knowledge in knowing that they have the right to direct the upbringing of their children? No. In fact, we have a Supreme Court justice that can't define what a woman is. Do I really respect her opinion about my right to raise my child given to me by God, not the United States government? So family is the foundation of America. If parents do not have the authority and the right to raise their children, I think we are in a very dark place And I fear for the future of America. And that's why I ran for school board, and then COVID happened. And I saw that the government thought that they knew better than us for our children. The superintendent of the school wanted to create a medical committee. If you're on a board and you have a committee of experts that are going to come in to give you recommendations, it's very difficult to go against those experts. And I remember before that committee was created, I looked at the superintendent and I said, "Sir, I don't think you understand. We don't co-parent with the government. You can't pick doctors to tell me what I need to do with my children, even when I take my kids to their own doctor. That's a recommendation that I can take or not take." And so, again, yes, there are some parents that are not very good to their kids. Abuse does happen, and we have child welfare laws in place in the United States to try to protect those children. But the idea that we would be making laws or that the future of our country would hinge on the worst actors rather than giving parents the benefit of the doubt and knowing that they love and respect and want the best for their children than anyone else, there's just no future in America in that. So thank you for having me.
Thank you. Let's start. Any panelists have a reaction to anything said by other panelists?
I would note that I don't actually disagree about giving a presumption to parental authority. I think that is generally best for children, and I would simply reframe it as something we do for the sake of the child and not for the sake of the parent. When you speak about parents' rights, you are necessarily saying because of their interests, we must do something for them. The state owes a duty to them to give them certain legal powers because of their interests. And justifying that kind of rationale, I think, is extremely difficult. I don't think any philosopher has succeeded in doing it. So I'd like to shift the conversation instead to about what is best for children, what might they be entitled to in terms of parental authority. And responding to Tiffany, I'm curious how you would resolve a certain tension between your skepticism about the courts and your suggestion that what you think God has done or said ought to be instantiated in constitutional doctrine, if I understood you correctly. So how do your views about what God has done or wants get effectuated in law?
If I might just respond first to the first part, is I don't think you have to think about rights as kind of narrowly protecting individual interests. I think when you think about the issue of parental rights, it's more of a structural issue about whether there are pre-political communities that have their own authority that are prior to the state. So when I think about parents' rights, I think about recognizing the existence of families as pre-political units with their own natural authority. And I think this is justified on purely philosophical grounds. I mean, certainly religious grounds would further support this, but you can make a purely philosophical argument, as I've done in many places for this. And as you know, the long tradition that I mentioned, people like Locke and Blackstone and Kent, and it's deep in our own legal tradition and in the English common law tradition prior to that, this idea that there is a natural authority structure prior to the state. And this is essential, I think, to limited government. The idea that the government is not the only authority in town delegating authority to all others, that there are other sites of authority that are original, not derived from the government, and that the government has an obligation to respect those prior authorities and their unique spheres of competence.
So Jim, you're a very smart man, and you asked two questions in there, and I'd just say back to you, ask me like I'm five. Ask the question very simply. Are you what is your question? You're questioning a parent's right to obey God in the direction that he's given? Is that?
I'm asking a question, I guess, about the courts and constitutional doctrine and how you think the Supreme Court, about which you have some skepticism, should resolve conflicts where parents are disagreeing with the state. And should they be invoking divine authority to do that?
I think that we've come to a place in our country where we are questioning whether or not there's something other than men and women, which is a biological fact that we all recognize and know, and that science backs up. XXXY chromosomes, men and women, complementary, as you've stated before. We don't need the Supreme Court to weigh in on that. although I'm sure there are some people that would like the Supreme Court to weigh in on that now for some clarity. But the idea that we would need, I mean, America's a lovely country. We're coming up on our 250th anniversary. But the structure of family, of parents, of the Bible, of the direction of God is something, as has been said, that's pre-existing. And so I think it's a little scary, honestly, when you have situations where you're looking to the Supreme Court to kind of dictate what the role of the parent is in the life of the child.
Well, again, I think we largely agree on sort of an observation about how society has developed and what seems to work well. And I'm just wondering why we want to throw the terminology of rights onto it and inject it into the Constitution. And philosophers try to be careful about concepts, and the concept of a right does not fit well with everything you might want to say about the family. A right does entail a duty on the part of someone else to the right holder, and duties are owed to people because of their interests. So you are necessarily saying something about the moral significance, the constitutional significance of parental interest for their own sake when you assert parental rights. If you want to talk about children's interests, which is usually where we end up, right? Usually the conversation ends up being about what is best for children, but then the framing should be different. If you're going to speak coherently, you should refer to children having a right to X because it is conducive to their important interests.
I mean, I think some of this is semantic, and again, I think you're using a particularly narrow view of a right, not necessarily the view of a right that has been dominant throughout our legal history and tradition. I mean, you see the understanding of a right in the natural law tradition, a kind of precursor to the common law tradition, as basically capturing what are the requirements of justice from the perspective of the beneficiary. So when you're talking about parental rights, you're asking, well, what are the requirements of justice in the state's relationship to the family and to parents? And the requirements of justice, among other things, are that the state respect the prior authority of parents to make decisions on behalf of their children, unless those parents have been proven unfit, proven guilty of things like abuse or neglect or doing things that seriously threaten the public order. And I think we can very coherently describe that as a right.
So would it be fair to say it seems like one of the important splits here is, do we think about parental rights as a good in their own sake or as instrumentalist? Would that be fair to say? It seems like one of the questions is, and I think you touched on both, Melissa. Mm-hmm. You touched to some extent on just this authority as existing in state of nature before there's government, but you also touched on what people often say, which is parents are usually in the best position to determine what's in the best interest of the children. So I guess I'm curious what everyone's view is are parental rights valuable in their own sake? In other words, if I were omniscient and I knew what was in the best interest of child and it was slightly different from what the parents wanted to do, would it still be best for the parents to make that decision because there's something just a good in itself about parental authority? Or is it just the fact that we're not omniscient, and so in the long run, the best outcomes for children happen by letting parents pick? Because in the long run, in general, no one else can do better than parents. And that seems to at least touch on what James was getting at, which is the ultimate goal here about parents or children?
You know, I would say I've given some thought. We had a nice dinner last night together, and we kind of chatted about some of these things, and I've given some thought to the idea of parental rights. It's not a terminology that I've used in the past, Jim. It's not something that I really thought a lot about, honestly. There was never a question as to who had the authority to direct the upbringing of my children until the government came in and questioned and challenged that authority. And so I'm happy to reframe or restate parental rights, to call it something else, to talk about what's in the best interests of the child. But I think we find ourselves in this place, and I'll speak, on behalf of the common people, where we're calling it parental rights because we are actually having to stand in defense of our children, in between the government and our children, who we see are trying to harm them.
That can be done by invoking your children's rights, which would be my inclination, and so I'd ask you to think about why there's so much resistance to speaking in those terms, why the insistence on invoking parental rights, which clearly draws moral attention to the parents instead of to the children. And if we're going to talk about authority rather than rights, and again, that's an important distinction to answer Tommy's question, I think there is you can call it gray zone or intermediate zone, where you say maybe parents aren't doing what others might think is best, it's unclear, or maybe it's clearly bad but it's not really bad. Then yes, for the sake of family harmony and insulating the family from interference, for the closeness of the relationship, then you say stay out, right? You need a pretty strong reason to interfere with what parents are doing.
And I completely agree with that, right? I mean, there's an example that liberal political theorist Eamon Callan uses in his book, Creating Citizens, where he says, look, nobody thinks that if you have parents who make a perhaps imprudent decision to spend, limited resources on a trip to Disney World rather than giving a talented kid piano lessons. Now, probably, if you think about it, you'd say, well, the child with musical talent, the money would be better spent on the piano lessons than the trip to Disney World. But nobody wants a world where the government steps in and says, oh, you can't spend that money on the trip to Disney World, you better give the kid piano lessons. But there's the question of where we draw the line. And I don't think there's any good place to draw that line other than abuse or neglect and, again, serious threats to the public order. We don't want a situation where any state bureaucrat, including public school officials and public school teachers, can second guess what parents think is in the best interests of children, again, unless the parents are proven unfit or proven guilty of abuse or neglect.
And I would just also ask, we've talked a little bit about children's rights and the current state of children's rights. The United States, I think it's the United States and Somalia, the only two countries in the world that didn't ratify the Convention on the Rights of the Child, the United Nations Convention. So is there a place where children's rights are enumerated where we can discuss what you believe those are? And then as a society, when we lose our moral fabric that has tied us together for quite some time, and people would say that religious affiliation, being a part of a faith, was a big part of that, and this line between adult and child is blurred, and the left continues to blur that line, queering our society, right? Tearing down traditions and norms and principles. This idea of age appropriateness for children, the books we find in the libraries, those types of things, I think it becomes harder and harder to be able to define what the rights of the child are collectively as a country.
I think that's right, and you make valid points about the challenge and what to do in the face of uncertainty, and probably deference to parents in many contexts makes sense. I would suggest that maybe the schooling context is somewhat different because, putting aside homeschooling, if parents are sending their children out to a different environment where there are different authority figures, any intrusion on the part of the state, say in the form of regulating curriculum and so forth, is perhaps less invasive, less disruptive. Already, again, the parents are accepting some other authority in their children's lives, and the children are not at home, and nobody's knocking on the door at home. So, blanket assertions about the state staying out of the family and protecting the sanctity of the family maybe have somewhat less purchase in that context. And what might be best for children in the broadest strokes is some separation of powers over their lives so that no one has a monopoly over them. And one way I like to think about this is through the heuristic from John Rawls of imagining that you're going to be born again tomorrow and you have no idea who your biological parents will be or who will raise you. They could be people adhering to any sort of worldview, faith, practices whatsoever. Would you want them to have a complete monopoly over your life, or where would you sort of draw the bounds of parental freedom and power over your life in that circumstance? Would you want some other authority to have some role in your education, for example, so that you're exposed to different ideas and can become autonomous and decide for yourself at some point? Or would you be fine with allowing your parents, whoever they might be, to be able to completely control your intellectual formation, even keep you at home in the form of homeschooling with no oversight whatsoever. So it's a thought experiment that I would invite people to make.
I mean, I think the trouble with that thought experiment is it first of all, overstates the extent to which even the most controlling parents can actually succeed, especially in today's day and age, in sheltering children from diverse perspectives. Children do, in fact, almost necessarily come into contact with diverse perspectives, regardless of how hard the parents try to shelter them. And I also think you have to consider, I think people of goodwill can have disagreements about the extent to which and the point at which exposure to diversity and to criticisms of the parent's worldview are helpful rather than harmful. So there are issues about age appropriateness, there are issues about the child developing a kind of stable core sense of identity that is in continuity with the family, and there are psychological difficulties with children being exposed, especially too young, to views that are critical of those of the parents. It can create rifts within families. It can destabilize the child's basic sense of identity. And so psychological and sociological studies support this. So there's also a question of timing, and my view is, look, if even in the worst case scenario, again, short of abuse or neglect, but parents who almost totally shelter their children from diverse views, but who educate them in a basic way, that children know how to read, children know how to be functioning members of society, well, when they are 18, they're then going to be exposed to the broad range of views in society. They can read. That already means that they can be exposed to a broad range of views outside the family, and they can make decisions for themselves. And there are lots of examples of children raised in very sheltered households who then as adults go on to reject their parents' views or modify those views and take very different views themselves. So it doesn't seem like sheltering children from diverse worldviews necessarily cuts them off from a range of possibilities or from the ability to make their own decisions as adults.
So the question was raised, why do we talk so often about parental rights and not, talk as much about best interests of the child? And I think one common answer is that it's lawyers' fault or policymakers or terms of art fault, in that in the context of these legal disputes in constitutional law, best interests of the child has come to be a shorthand, even though it doesn't have to be, for what the government thinks is the best interest of the child. I think particularly of the Troxel versus Glanville case from 2000. I think the most recent case at the Supreme Court to discuss parental rights as a constitutional matter, where it was essentially a conflict between a mother who didn't want her kids to have as much time with their grandparents, their deceased father's parents, versus the grandparents who did want to have more time. And a judge sided with the grandparents, said in the judge's view, it was in the best interest of the child to have more visitation time. So when in a legal dispute we're talking about best interest of the child, it almost always means is in conflict with what the parent wants them to do, because if there was no conflict, we wouldn't have a court case. So that may be kind of a perverse effect of these disputes or these shorthands we've made, where best interest of the child really is like what a judge thinks or what a policymaker thinks is the best interest of the child.
Yeah, I mean, I agree. I also think there's an issue of a kind of tiers of authority, right? So nobody, I think, disputes that there are times and places where the state ought to step in. But the question is whether the authority of parents and the state are on the same plane. And I think when you just say, well, it's all about the best interests of the child, you lose the important distinction that the authority of parents is on a different plane. It's a prior authority, and there's a presumption that parents know best what's in the best interests of the child. And only when there's a strong evidence to override that presumption can the state even step in and begin to make its own independent judgment. So I think you need to capture this two-tiered structure of the layers of authority, and that the parental rights language is, in my view, at least legally, what serves to best capture that.
Tiffany, you brought up a conflict with the school and the parent, the scenario where the school is calling the child by a different name than the parent wants, and that was part of what got you involved in the parental rights movement. I think the trickier scenario for you or your policy views that we should usually rely on the parent's role is, what if the parent and the child are aligned, but in choices that you think might be harmful? So we have a case pending at the Supreme Court right now called Skirmetti, where Tennessee has banned sex transition surgeries for minors, even if the parent agrees with the child. So even if the parent, a doctor, and a child all want this surgery for the minor, they can't have it. So the policymakers just said, this is abuse, this causes long-term harm. So how, to some extent, this whole discussion is about how do you draw that line. But if you think in that scenario, parents should not have the right to approve it, how do you distinguish that?
Sure. The false consensus of every major medical institution in the United States of America does not justify the right of the parent to abuse their child. And very quickly we have a number of cases pending across the United States of America, as well as new leadership within the Department of Health and the NIH and the CDC that is going to bring light to how incredibly abusive so-called gender-affirming care is. The idea that you could stop the natural, healthy development of your child, that you would want to do that, or that somehow putting your child on puberty blockers and cross-sex hormones would only affect the development of their secondary sex characteristics, rather than rendering a 15-year-old with a double mastectomy and the bones of an 80-year-old in the middle of with horrible osteoporosis. So we haven't had honesty around that. There's a study that was done out in California by a doctor, Dr. Kennedy, that the NIH funded. She's withheld the results of the harms of these drugs. And so there will be a lot of clarity and light. There's a tidal wave of evidence that is cresting in the United States, and our friends in Europe who we've normally been ahead of them on a lot of issues are actually ahead of us. And so I think that particular situation isn't a good example to use when we're talking about the authority of the parent to make decisions in the best interest of their child, because unfortunately, as I said, every major medical institution, the AMA, the American Academy of Pediatrics, have all been captured. But I promise you, if it's the last thing I do on this earth, we will stop gender ideology, and parents will not have the ability to abuse their children. Now, I would like to say this. I have a lot of compassion for parents that have gone through this or want to do this for their child, because they're being told, do you want a dead son or a live daughter? They're being threatened by the idea that if they don't affirm their child, somehow their child might do self-harm. That's a lie. They're being told that this is in the best interest of the child. That's a lie. And so I believe that parents deserve accurate information when making decisions for their children. And when parents have accurate information about the true harms of gender ideology and so-called gender-affirming care, this nonsense will stop.
Response?
I think you identified two criteria for finding that parental choice of a medical intervention is abusive. One is that it alters the course of the child's development from what it would otherwise be. And the second is that it has adverse side effects. And I wonder if you would generalize that to say that any medical intervention parents choose that has adverse side effects and changes them physically in some way is abuse.
I think what she means is that these procedures, I'm not even going to deign to call them medical treatments because there's not enough evidence of benefit to say that, but these procedures and interventions either directly cause irreversible damage to basic bodily function, the sort of change that no 12-year-old, not even 16 or 17-year-old can actually understand and consent to. And so, I mean, and there's a long history of public health regulation and intervention, particularly on behalf of children, but even on behalf of adults, in order to protect people from unsubstantiated medical interventions that will irreversibly damage the body, that will irreversibly stop basic bodily functions from happening. And these procedures either directly do that, or they, in the case of puberty blockers, place children on a trajectory in which they are likely to take the next steps to do that. Whereas if you simply allow the child to continue to kind of explore things, but without affirming, without pushing them in any direction, without social transition, and certainly without any kind of medical steps, in about 80 to 90% of cases, the gender dysphoria naturally desists. Whereas if you start them on this process of social transition and then puberty blockers, almost 100% proceed to cross-sex hormones and then often some form of surgery. And that, we know, permanently sterilizes children and has irreversible, lifelong medical harms. So I think just on the basis of normal public health regulations, you can say, at least for children, we cannot allow parents to make these irreversible decisions that will cut off basic bodily functions for them. Even in DC, there's been a long-standing law in DC that actually prevents a lot of these treatments from happening here just by accident, because it was prior to all the kind of gender ideology becoming popular. And because DC has a law against any kind of medical intervention that would render your child sterile. And that's non-controversial.
So we've, at a high level of generality, maybe the highest level, we have some consensus that everyone here agrees the state at a certain point can override the decisions of parents in cases of abuse. The devil's always in the details of how do we define abuse, and it's especially tricky when you have, a country of over 300 million people and trying to find consensus. We're going to be moving to Q&A now, both in the audience and online. A reminder to the online audience, you can join the conversation and submit questions directly on the event webpage, on Facebook, on YouTube, or on X.
Can I mention something quickly?
Sure.
I think your point that, every time we start to talk about what's in the best interest of the child or children's rights is always at a point of conflict is really important. And I don't think, and Jim, to your point, I don't think we're having enough productive conversations about truly the best interests of children. This parental rights initiative that I've joined the Heritage to lead will have an event series along with it. And the event series is called What's Best for Kids. And I'll be inviting folks from Cato and other policy groups and think tanks to come and talk. I'll be inviting parents to the table to come and talk and have robust conversations about some of the biggest issues that parents are really grappling with: education, technology, medical care. What is best for children? And so, I really respect your perspective on that. And I do think it's time in America that we start prioritizing children. We'll be a much better country for it if we do. Mm-hmm.
We have a few online questions already. One, Donna asks, can the guests discuss where they see homeschooling rights heading? We haven't discussed homeschooling. Anyone want to take that?
Illinois, homeschooling was under attack in Illinois this legislative session. It's not always been legal in the United States of America, and as I think public schools and the teachers union see declining enrollment happening all over the country, parents who were a little nervous to homeschool before COVID tried it out, right? Because they saw their kids attached to a screen at their kitchen table and saw some of the indoctrination happening, and they said, wait a second. The experts told me I wasn't a teacher and I wasn't supposed to teach my child. No, parents, you are the best expert for your child. And you can absolutely teach your child. So I think a beautiful resurgence of homeschooling, tons of new resources and opportunities, the internet, and really offers parents so many tools. And I think homeschooling is going to continue to grow. But I do think that you'll see the government, certainly in blue states or in more left areas, fight against the autonomy of the parent to educate their child.
And I think in terms of legal rights, I think if you understand the strong tradition of respect for parental rights in our nation's history and tradition, it's clear that the right to homeschool should be a protected legal right. Again, as long as parents are actually teaching children the basic academic skills, then I think the state should generally stay out of it.
In the book I co-authored on homeschooling, I begin in a very unusual place, which is with children's rights and the right of the child to stay home. And I say, the government can't order any of us adults to leave our home to get educated, right? Why wouldn't children have that same right? And so the burden is on the state to justify forcing the child to leave home to go to regular school, which I think it can't do. Unless it's impossible to oversee homeschooling to make sure that it is adequate in certain respects, about which people can disagree. And I don't think it's impossible. I think it is possible to allow for home education. And my position was just that there needs to be some state oversight. I think it was Melissa who said early on that we shouldn't let the unusual case drive the law or policy. And I think that's the power of the Rawlsian heuristic of imagining yourself in the worst position, so to speak. So when you speak broadly about parents generally doing what's best and caring the most and so forth, but I want you to imagine yourself being born tomorrow to parents whose views you think are the most obnoxious, the most contrary to your current views, whose practices you think are harmful. Maybe they have gender transition ideology or whatever it is that you think is really noxious. Imagine those are your parents. Would you want some legal protections to be in place to guard your interests against the choices that your parents might make? Which amounts to saying, yeah, the aberrant case might provide a foundation for legal rules that everybody has to abide by just to protect the worst off, the most vulnerable.
And we have child welfare laws in the United States of America that do protect children from abuse, and as I said, gender-affirming care is child abuse. So I would just put that right in there.
And I think
Right,
you
in
also
the homeschooling context, you might need that as well, some interaction between homeschooled children and persons who are not controlled by the family, some independent, not something highly invasive, but just a little check on to make sure the children are developing well physically and intellectually.
Let's go to audience questions. And raise your hand if you, yeah, we have one back there. Wait for the mic, and please identify yourself and your affiliation.
Hi, my name is Beatrice Marnay. I'm with ESSET and Child Exploitation Think Tank. And one thing we don't discuss when we speak about parents' rights is that family courts are a hidden entity to protect the child and the privacy of the child. Yet, every time I look at a case audit, laws are being circumvented, case files are being lost or mishandled, and at the end of the day, when a social worker takes your child, they can do whatever they want, even though the parents still have rights. And they, most of the time, 80% of the time, they have not done anything wrong. So there is a way to actually manipulate parents' rights. And that's one thing as people in child welfare don't understand, and that puts the child in the most harm.
Is there a specific question for the audience related to that? More of a,
I'm sorry?
oh, is that more of a, well, any reaction?
I mean, I can say, I was actually going to say something in response to Jim's concern is that when you're thinking, the reason why the aberrant case doesn't make good policy, I mean, yes, if you imagine yourself in the household where it's just, an inch shy, metaphorically, of abuse or neglect, and you're the kid in that household, you might say, maybe I want a little more state intervention if I were that kid. But then you have to balance that against, okay, but then how many thousands of children of perfectly loving parents will be then removed from their homes or will have social workers inserted into their home life in ways that are extremely disruptive, often traumatic? I mean, when I go around and speak about this, almost every single time in every single audience, I have people come up to me afterward and say, oh gosh, yes, I know my neighbor, wonderful kids or wonderful parents. They're so conscientious, loving. They had their kid taken away. Their baby was taken away for months on some, trumped up suspicion of something else because they came to the doctor and there was a bruise that, they couldn't give a sufficient explanation of, or some, neighbor gave an anonymous call to Child Protection Services. They came to the door, they took the kids, or they came to the door, they did an invasive search that was traumatic to the kids. I mean, these things happen every day, and there are huge problems in the system. And I'm not saying there do need to be child welfare protections in place, but we need to ensure that there are actual correct due process protections for parents in the system where they are actually innocent until proven guilty. And I also think where they receive the ability to have legal representation in these cases that are brought before the family courts, because currently that's not how it is. Currently it's almost a guilty until proven innocent scenario, and parents don't have rights to legal counsel, even though this is a huge area of where the state enters and disrupts the family, usually with great harm to children in the process.
We have another online question. Will parental rights ever include the right to allow a minor to work or enter into an apprenticeship agreement? This is something where maybe standards have changed compared to 100 years ago in terms of the norms of child labor. Any reactions to that? Melissa, you looked at.
I mean, I don't have any kind of strong views on this. I mean, I think there are certainly reasons to have child labor laws, but I think you need to look carefully at them because some things like apprenticeship scenarios or some level of work in childhood at certain ages can actually be part of a child's education and training and beneficial to the child. So I think you need to look at this more on a fine-grained case-by-case basis. And see whether the current child labor laws are preventing parents from being able to offer educational opportunities to their children that might actually be helpful to them. I think what you want to avoid is any scenario where children are pushed into labor that prevents them from being able to get the necessary academic education that they need, or being pushed into labor that would be unsuitable for their bodily strength and that would prevent them from getting needed rest and things like that.
To me, it sort of raises a recurring issue of how do you deal with changing norms of what kids are owed or what's too much to put on their plate. I think about also the debate about so-called free-range kids, how 12-year-olds walking to school alone was the norm in the 70s, and parents get arrested for that in the 20s.
6-year-olds walking to school alone was the norm in the 70s.
Yeah, and so I'm curious, how does the panel think about these changing norms? I mean, do you think you have to go by whatever the current era is, or were we more correct in the past? And what if a parent, just says, it used to be the tradition to be a paper boy, or it used to be the tradition to ride, I rode the subway when I was 8. How does government deal with that if that becomes a distinct minority view?
Well, there are two aspects to that, I think. One is that the world has changed. If you think the world has changed in certain ways that require parenting to adjust, and that seems valid for the law to expect, or for parents to expect of each other. Another is just changing attitudes or views of what is optimal for children, and in that, with respect to that, I think we would agree that parents should have more freedom to choose what approach they.
It's so interesting. I was just having a conversation with my daughter, who, if she watches this, will kill me. But the government sometimes does things that encourage parenting to change or our culture to change. I would think college and subsidizing college is one of those areas. And 20-year-old daughter, there were a conversation happening with friends about this is my time of my life to explore and to travel and the idea that 18 years old, that you're not working, that you're not supporting a family, that you're putting off having a family in general. All of these things have changed. This idea that we suspend reality for 18 to 22-year-olds, this has become normal to us as a society, is kind of crazy. And there's certainly a correction happening. I think COVID kind of corrected that. I think some of the different things with student loans is going to correct. But the government has done things that have encouraged these cultural shifts that I don't think have been in the best interest of family, and of parenting and of children in general. And I think we have to grapple with those things too.
Audience over there in the corner, wait for the mic.
Thank you. Will Estrada, Senior Counsel at the Homeschool Legal Defense Association. Great event, great panelists. So Cato, thank you for having this. My question is specifically to Professor Dwyer, but curious on some of the other thoughts. Professor Dwyer, you've talked about increased regulation for homeschoolers. There was a discussion you had with Harvard Law Today in 2021 with Elizabeth Bartholet, where I think you said at a minimum there should be background checks before parents can homeschool. And I would suspect the reason you would say for that is because kids in public and private schools are in front of mandatory reporters. But what's been perplexing to me is the research shows that it's 1 to 2, 3-year-olds who are at most risk of child abuse and neglect fatalities. And so are you also saying that really children of all ages from birth to say 7 their parents should have background checks done before they're sent home from the hospital, for example?
Well, I can be really provocative and just answer simply yes. There's two aspects to that. More or less, that's the answer. So With respect to schooling, when you get to school age, yes, the rates of maltreatment appear to be less at that point. But again, if you're worried about the worst case scenarios, and there have been examples of parents using homeschooling just as a way to avoid detection of maltreatment. So ideally, you'd want to detect those, but not have a huge side effect on other families that are fine, right? But a background check is really non-intrusive, right? You just take the parent's information, identifying information, run it through a state data bank. And at birth, something that many people aren't aware of is that there are now 5 states doing background checks on birth parents. It's called Birth Match. And so Michigan, Minnesota, Maryland, Missouri, and Texas have this program where birth records are sent to the Department of Social Services. You just put these 2 bits of information together, the records of past maltreatment and a new birth, and see if birth parents have a history that is very troubling, like a prior termination of parental rights because of maltreatment. So we are doing that in some places, and there is a law with which you're familiar, I'm sure, proposing background checks when people inform the state that they plan to homeschool. And yes, I would support adoption of that more broadly.
Any other reactions on the panel? No, that's fine. Polly,
No, I mean, yeah, sure. I think this brings us to this moment of like the decay of the moral fabric of our country, and the fact that, you know, some of these things government can't fix home. You know, we have the sanctity of the family, the role of the parent, the relationship and the sacred relationship between the parent and the child being respected. These are such fundamental core issues. And so I think it's preposterous, the idea that you would do background checks on parents to be able to homeschool.
probably time for one more question. Let's see. Got one there. Please keep it quick because we're near the end.
J.P. Hogan, the separation of church and state, but it's also more the recent decision on charter school 4-4. There's a puzzle there that if that's the right decision, or is the court saying that secular socialism and the welfare state would also be unconstitutional? So it's a matter of, if you're going to say you can't fund the education, can you fund, like doing God's work as the government doing it? Seems like you can say that decision's okay, but you then have to argue that the separation of church and state is the government's also under God. It's not equal standing for secular socialism.
So this is in reference to a 4-4 split decision the Supreme Court just issued about the question, essentially, can you charter, is it constitutional? May a state permissibly exclude religious schools from the charter school program? And the debate is essentially, should you think about charter schools like vouchers, or should you think about them like public schools? Traditionally, the notion is a religious public school would violate the Establishment Clause. It would be too close to an establishment of religion. So given that it's a 4-4 tie, I don't think we can read really anything into the decision. I don't know if you have, but probably likely to come up again at the Supreme Court, would you say?
Yeah, I mean, it seems to me that the main legal question is whether charter schools are state actors or not. And I'm convinced by the work of many legal scholars that they are not state actors, that they are similar to other agencies that governments have historically contracted with to provide services, things like charitable institutions, foster care programs, adoption agencies that have often been run by religious or other nonprofit, non-governmental actors. And so if you're recognizing that these are non-state actors, then I think it would be a violation of the First Amendment to exclude particular schools from being even considered from participating in the charter program simply because they are religious. So that's basic religious discrimination. Now, as a policy matter, I think the better way to go with this on school choice is to have just more general school choice policies with no strings attached where the money goes to the parents and then the parents choose the school of their choice, because charters will, as government contractors, will always have more government strings attached. So I think there are just more dangers to that. But as a matter of constitutional principle, I think they should win such a case. And I think if a similar case is brought again before the court and Justice Barrett does not feel the need to recuse herself, I think it's pretty clear that they would win.
We're out of time. We have to end there. Let's show our appreciation to this great panel. Absolutely. Absolutely. Thank you. All right. And I believe we have a 5-minute break now before the next panel.
Welcome back, and thank you for joining us for the second panel at our Cato Conference on Parental Rights, celebrating the 100th anniversary of Pierce v. Society of Sisters. We're going to be talking now about educational freedom. Has it reached escape velocity, and is that a good thing? So I'm joined by a very wonderful panel here. I've got Neil McCluskey, who already introduced himself, the director of the Center for Educational Freedom here at Cato Institute, and my boss. And then next is John Valent. He is the director of the Brown Center on Education Policy at the Brookings Institute and a senior fellow in governance studies, and he holds the Herman and George R. Brown Chair in Education Studies at Brookings. He specializes in pre-K to 12 education policy and politics, and much of his research examines inequities in U.S. schools and the policies that mitigate or exacerbate those inequalities. And a lot of this includes, of course, work on school choice. And then Michael Bindes is a senior attorney at the Institute for Justice, and he leads IJ's educational choice team, and they do a lot of work defending educational choice policies around the country, including he's worked on the recent Supreme Court cases, Carson v. Macomb, and Espinoza v. Montana Department of Revenue. So this is a really good panel to take the conversation that we just enjoyed on parental rights in general and looking specifically at education and educational freedom and how do parental rights play into this. So starting with Neil, they'll each give us a little bit of an introduction, and then I'll ask some questions, and then we'll open it up for audience questions. And just like in the previous panel, if you're watching this online, you can ask through the event page, through Facebook, through YouTube. You can ask directly the questions there. Or if you're watching it on X, you can use the hashtag Cato Events. And using that hashtag will make sure that we see the questions that you're asking.
Great, and I put this together, and I should have introduced you. So this is Colleen Ronchek, who is our policy analyst. She does great work on all sorts of school choice, and in particular, you want to follow her on the Friday feature, which every Friday goes on Cato's blog and talks about new and innovative ways to deliver education. So thank you, Colleen, for moderating this. And I want to thank the first panel, which I thought was really excellent, a terrific discussion. And I hope we can equal that. We're going to do our best, right, I guess? All right, I'll try. So the question for me is, and for this panel, is why school choice? And now I will say that I don't actually think the grounding for school choice is in parental rights. I even take some issue with the idea that parents have an inherent right to make decisions for their children, because the libertarian default, I think, is that no one has an inherent right to make a decision or impose something on someone else. But it's sort of a moot point for me, because I think for many reasons it is far better that parents make decisions for children than government. And some of these were already discussed in the first panel. But it basically comes down to three things. First, parents really naturally make decisions for their children. Children are born to parents. They're born into family units. And we have to remember that children can't or are not assumed to be able to make informed, reasoned decisions for themselves. So somebody has to make those decisions, and naturally that falls first and foremost to parents. I think that then we look and we assume that parents will know their children better and will be much more motivated to care for their children than bureaucrats or other people. Biologically, we are driven as parents to care much more for our children than anyone else, than any stranger. And I think bureaucracies or government are particularly poorly equipped to care for children because bureaucrats are not evil, they're not angels, they're regular people, but the work of a bureaucracy tends to be very regimented, very structured, as far as you can be from being able to give specific, unique care to each child, because the nature of a bureaucracy is as a system, it's almost sort of like a factory. And so parents are much better situated to take care of their children and to care for their children than other people, and especially government. But I think the most important argument for making parents the drivers of decisions in education in particular for their children is that that is what's consistent with a society of diverse values and diverse communities that is grounded in liberty. That means letting lots of people make lots of different decisions as opposed to government making one for everyone. Government control of education tends to homogenize and is ultimately grounded in force, and force that could be used for very bad ends when it is applied across a society to all people and to all families. And so I think it is much more consistent with a free and harmonious, liberty-based society that parents are the default for decisions in education. Now, part of the topic here is, have we hit escape velocity on school choice? I think we have, and for the reasons I just stated, I think that's a good thing. At the very least, I think we are beyond any point, at least in the foreseeable future, where we will go back to an assumption that where kids go to school is the public school to which they are assigned based on their home address. I think we don't, at least in the foreseeable future, return to that being the assumption for most people. The assumption now is everybody should have some sort of choice, and I think we're very close to saying private choice on a relatively equal financial footing and playing field is the choice that everyone should have. So I think we can have terrific discussions about the limits of school choice. I think that was discussed in Pierce, as I quoted earlier. But I think choice must be the basic foundation of the education system. Over to you.
So thanks, Colleen, for having me. Thanks, Neil. And thanks, too, to all the Cato folks who are working hard to put on this event. I'm going to start by kind of laying my cards on the table about what I think about the direction that the school choice movement has taken. I'm not particularly optimistic and not fond of the direction it's taken. And then I'll give kind of my 30,000-foot view of why I think we're going in the direction we're going, which I'm sure everyone will agree with, and then we can just stop and go home.
Off to lunch.
Off to lunch. So I worry a great deal about this new generation of school choice reforms, and I'm talking specifically about state-level ESA programs, so education savings account programs, and more recently, the federal tax credit scholarship program. I worry a lot about a lack of accountability, about a lack of transparency, about the absence of quality control mechanisms in those policies, about a lack of protection from discrimination against students in admissions, and really a whole lot of other things. And particularly, I worry about the way that I think these policies are and will continue to direct resources from more disadvantaged areas to more prosperous areas, and particularly will hurt the rural poor. And to me, I say that, though, not as one who is instinctively opposed at all to school choice. I actually, at the same time, believe very much that there is something that is hypocritical and elitist when people who have lots of say over which schools their kids attend want to tell other people that they can't have choices. I believe in school choice. I think families should have school choices. And where I think we are and where I think this is coming from is there has always been this kind of interesting phenomenon with school choice, which is that you can make a case for school choice policy from very different principles. And those principles tend to appeal to different groups on the political spectrum. And this is, I'm oversimplifying a little bit, but for a long time, political conservatives have liked the kind of efficiencies that come from school choice. So for those of you who are familiar with Milton Friedman's work or Terry Moe's work, that's the idea that we have producers, we have schools, we have consumers, parents and families, and as you let parents pick the schools that they think are going to serve their kids best, maybe you just have a more efficient production of education. So it's less expensive, you get better quality. That's the kind of view that I think tends to appeal to conservatives. There's a second view that I think is rooted really in liberty that tends to appeal to libertarians, which is essentially, and I think we heard a lot of this on the last panel, the idea that parents and families should be able to get what they want, right? That you shouldn't be subject to the whims of government, sort of wrapped up in government bureaucracy and goals. And then I would say there's a third perspective that really appeals more to progressives, which is the idea that it's just fundamentally unfair that families that have resources can pick where their kids go to school by paying to live in places that have schools they want, and that same right isn't afforded to families that don't have those kinds of resources. And for a long time, I think really for decades, there was a coalition that was fragile and it was delicate, but it held, that stitched together those different groups, which all brought their different perspectives on why we might need some kind of school choice reform. And the policy manifestation became charter schools, because charter schools were ways for families to opt out of the traditional school system, to sort of exit that bureaucracy in ways that I think appealed to a lot of conservatives, but at the same time did have some guardrails around them. They were sort of set up in ways where they tended to benefit the least advantaged kids, and had sort of enough appeal with a wide enough group of families that you saw this, I think it's something like 46 states now have charter school laws. And to my eye, essentially what happened is, as we as a country just got worse when it comes to anything that involves any kind of bipartisanship, we started to see those coalitions fray. And in particular, I think we started to see progressives leave and sort of lose interest in charter schools. And where I think that left us was we had conservatives, we had libertarians who were kind of looking at the school choice policies that we had been, we as a country had been pushing for, and said, this isn't really where their hearts were in the first place. And so from charters, we then now get this push towards private school choice programs. And what's missing in these programs is I don't think there is a strong kind of magnetic pull toward any kind of opportunity, equity, fairness. And I think that shows in these policies. So I think hopefully we can talk more about the Educational Choice for Children Act, for example, which is this big federal tax credit scholarship program that's on the table. But what I think these programs really lack is they just they are not set up in ways where they're likely to benefit the least advantaged, which for a very long time has been a guiding star for a lot of our school choice policy.
Thank you, Neil. Thank you, Cato, for having me here. As Colleen mentioned in the opening, I work for the Institute for Justice. We're a public interest law firm, and among other things, we defend school choice programs when they're enacted. Almost invariably, these programs are challenged by either teachers' unions or other interest groups that are hostile to choice, and we defend these programs on behalf of the parents and children using them. Surprisingly, Pierce and its predecessor Meyer have played very little, if any, role in the litigation concerning the constitutionality of school choice programs. They've played a very big role in the policy debates that have motivated legislatures to adopt these programs. I think legislators have seen these programs, and correctly so, as empowering parents to exercise the right that the Supreme Court recognized in Pierce to choose a private school for your child or to otherwise direct your child's education. But in the litigation over the constitutionality of these programs, strangely, Pierce and Meyer have played very little, if any, role. I think that's because the constitutional questions surrounding school choice programs over the last 3 decades since the birth of the modern school choice movement have really all concerned religion, right? When school choice or the modern school choice movement was in its infancy, the big question was, can you have school choice programs with religious schools, or would that violate the Establishment Clause? Thankfully, from my perspective, the Supreme Court answers that question correctly in Zellman versus Simmons-Harris back in 2002, and says, yes, you can have a school choice program that includes religious schools so long as the program is even-handed between religion and non-religion, and so long as it operates on the private choice of parents. No Establishment Clause problem. Then the question becomes, okay, the other side here, the opponents of choice would argue, well, it doesn't matter if you can have school choice programs with religious schools. states can still exclude religious options from these programs, or state constitutions can still be applied to challenge these programs because they include religion. Thankfully, the Supreme Court rejected that argument in a pair of cases in 2020 and 2022, Espinoza and Carson, which Colleen mentioned in the intro, and basically held that while a state is not required to have a private school choice program, if it does, it has to allow religious schools to participate. To do otherwise, that is to have a school choice program that excludes religious schools, or to apply a state constitutional provision that bars public funding of religious schools to invalidate one of these programs, a school choice program, would violate the free exercise clause of the First Amendment, specifically a parent's right to direct the religious upbringing of their children, and including the right to choose a religious school for them. So with that trio of cases, Zellman, Espinoza, and Carson, the big constitutional questions that had kind of hung over school choice for the last 30 years were answered, and they were answered in such a way that made it very clear that you can have school choice programs, they can include religious options, and they cannot exclude religious options. And because those questions were resolved under the First Amendment, the religion clauses of the First Amendment, the court didn't have to look to Pierce and Meyer and their kind of due process holdings about the right more broadly of a parent to direct the education of their children without regard to religion. The cases were much more narrowly resolved on religion clause grounds. That's changing, though. Certainly the fights over school choice, the legal fights over school choice, are not going to end. Opponents of choice are a very dogged bunch, and they will continue to challenge these programs no matter where they're enacted and under any kind of constitutional theory they can concoct. And I think Pierce and Meyer are going to play a bigger role in the litigation going forward. And I'll talk just very briefly about two specific ways that I see this going. One involves a variant of state Blaine amendments that we at IJ call public-private Blaine amendments. You all probably know Blaine amendments, generally speaking, are state constitutional provisions that prohibit public funding of religious schools. Some states, fewer, but some states have variants of these that prohibit public funding of private schools without respect to religiosity. They just prohibit public funding of all private schools. Thankfully, most states that have these provisions have interpreted them in a way that allows school choice. The courts have held that school choice programs don't aid private schools, they aid families. They are financial assistance to families, and it's families who decide where these programs are used, and therefore these public-private Blaine amendments are not an obstacle to school choice. But in a handful of states, and I literally mean a handful, you can count on one hand, I think there are 5 states that have these public-private Blaine variants. State Supreme Courts have interpreted them in a way that does seem to restrict or even prohibit financial assistance for families who choose private education. So that would prohibit financial aid for students whose parents send them to a private school. I think those types of Blaine amendments, these public-private Blaine amendments, are just as constitutionally problematic as the more conventional religious, non-religious Blaine amendments. Because I believe that just as a state cannot enact a prohibition on the legislature's ability to provide financial assistance to families who exercise their First Amendment right, their free exercise right to choose religious schools for their kids, so too can a state not enact an absolute barrier to the legislature's ability to provide financial aid to parents who exercise their due process right to choose a private school, religious or not, for their child. So I think that's one issue we're going to see being litigated in the coming years. We're litigating the issue currently in 2 states, in Alaska and Massachusetts. I suspect we'll be litigating it soon in South Carolina as well. And I think Pierce and Meyer are going to play a big role in that, because the whole question is, can a state penalize or bar financial assistance programs for parents who exercise the very right that the Supreme Court recognized in Pierce? And then the other way I see Pierce and Meyer coming up in litigation related to school choice going forward isn't so much with respect to the constitutionality of these programs, but rather with the constitutionality of regulatory barriers that we're increasingly seeing be erected to the new models of education that have been a kind of byproduct of greater school choice, and specifically of education savings accounts. As you all probably know, education savings accounts are school choice programs that can be used for a whole array of educational options. So it's not just tuition to attend a private school, but it's expenses associated with homeschooling, so to purchase curricular materials, textbooks, private tutoring, special education therapies. These programs allow parents to really kind of provide a customized education for their children to meet the very specific individual needs of their kids. And as a result of the proliferation of these programs, we've seen incredibly innovative new models of delivering education, the types of innovations that Colleen writes about, in terms of micro schools, hybrid schools, learning pods. These things were largely tolerated during the pandemic out of necessity because the public schools were just out of business. But increasingly we're seeing new regulatory barriers to these new models of education. These new models don't fit the old paradigm, right? It used to be public school, private school, homeschool. Some of these new models don't fall neatly into any of those categories, but government's trying to push them into these categories in order to regulate them, and in turn they're stifling the innovation that these education entrepreneurs are showing in trying to meet the needs of kids. There too, I think Pierce and Meyer are going to come into play, because I think one thing that often gets lost, that we lose sight of in discussing Pierce and Meyer, is that those cases were not just about the right of parents to direct the education of their kids or parental liberty more broadly. They were just as much about the rights of education providers to provide their services to families who desired them. Pierce was not brought by parents. Pierce was brought by two entities that operated private schools, the Sisters of the Holy Names of Jesus and Mary and Hill Military Academy. And in invalidating the law at issue in Pierce, the Supreme Court certainly protected the religious liberty of parent, or the parental liberty interest of the parents attending those schools, but it just as much was concerned about protecting the economic rights of the education providers. The court noted that the schools have business and property for which they claim protection, and these are threatened with destruction through the unwarranted compulsion which the state is exercising over present and prospective patrons of their schools. The court went on to say that the successful conduct of the schools requires long-term contracts with teachers and parents, and even though the law was not even yet being enforced in Oregon, the court noted that the law had already caused the withdrawal of children who would otherwise continue at the schools, and the court thus concluded that protection against this arbitrary, unreasonable, and unlawful interference with their patrons and the consequent destruction of their business and property was warranted. So again, the court is just as much concerned with the rights of the education providers. The same was true in Meyer, which preceded Pierce by 2 years. Meyer was not a case brought by parents. Robert Meyer was a teacher. He was prosecuted for the crime of teaching Bible stories to kids in German in a Lutheran school. And just as in Pierce, yes, the court recognized the rights of the parents of students who wanted to send their kids to Robert Meyer's school, but the court was just as much concerned with protecting the right of Robert Meyer to engage in the common occupation of teaching and to contract with families who wanted the services that he was providing. So that's the other area where I think increasingly we will see Meyer and Pierce play a big role going forward in litigation concerning both the constitutionality of school choice programs and the constitutionality of regulations that government might be imposing in order to thwart the kind of entrepreneurial side effects that we're seeing as a result of the expansion of these programs.
Thank you. So I was going to copy Tommy and start off first with asking if you had questions for each other. But before I do that, Michael's talk about the religious aspect of this made me wonder, John, with your support of charter schools more so than private school choice, what about religious parents who want a different option but can't afford private school tuition? Do you support religious charter schools like the Oklahoma case that was recently the ban on religious charter schools was upheld by the Supreme Court? Do you think that there should be religious charter schools, or should those religious parents just not have an option?
It's a good question, and I should say a couple things. So first of all, the line that I draw really isn't between religion and non-religion. What I'm much more worried about with these programs is the complete lack of guardrails around the programs that we're seeing right now. And so take, for example, and actually maybe I'll use this as an invitation to respond to something Neil said too. So Neil said, and tell me if I'm not representing this well, that parents are uniquely situated to understand their own kids, and that's important. And I agree with that very much. I think I'll even take that a step further and say, I think parents' love of their own kids is the single most powerful force in education. It's a very difficult one to harness, but it's a very real force. And this to me gets to really a question of quality control mechanisms. Like when we have school choice, whether it's religious schools, it's non-religious schools, whatever it may be, how do we know that when we as taxpayers are paying into this system and we're investing in these public schools, which are producing public goods too, not just private goods, how do we know we're actually going to get any quality out of the schools we get? If we rely on parents' understanding of their kids' education and where their kids are going to get the best education, I think we need to be very honest about how difficult that is for parents. And I mean, I'll speak just to myself as a father. I have 2 kids who are currently in schools, and I should know a lot more about my kids' schools than I would be able to know about the world of schools that we could choose. And the information I get about my kids' schools, I talk to them every day about what happened in school, and many of you with kids probably know how much information you usually get out of that. I get report cards. I happen to be suspicious of report cards because of grade inflation these days. I get reports from teachers that I don't really know all that much what to make of those either. I really don't know. Are my kids getting a good education where they are? Would they be getting a better education down the street or across town? I don't know. And that's for the school that they're attending right now. And I think we can take this a step further where you start to get into those cases that we talked about in the last panel, where you might question whether the interests that parents have at heart really are consistent with the child's interest. Even in the best case, I worry about that sort of quality control piece. And taking it a step further, and again, the line I would draw is not on religion. The line I would draw is in charter schools, for example, you have protections around who is able to what a school can do when it comes to saying no to a family that wants to enter. With these newer ESA and tax credit scholarship programs, depending on the state where they operate, you can have cases where a student who identifies as LGBTQ or as the child of LGBTQ parents can be told no. A school can say, fill out this attestation form that says that you are not gay and your parents are not gay, or else you can't come. I think legally, the school could also say, fill out this attestation form that says that you are not a Democrat or a Republican, or that you voted for whoever you voted for. And again, the school can say, no, you can't come. Those are the issues those are the lines that I think I would draw, where to me I'm worried about the direction this is taking, along with the fact that when we have moved in this direction toward private school choice programs with very weak restrictions with respect to who is eligible. You have money that is flowing to families who, for one, are already in private schools, or two, at least live in areas where there are private schools. And often that money is flowing from relatively poor areas to relatively wealthy areas. So I don't know that I have a particularly strong opinion on religious versus non-religious charters. I wouldn't even necessarily say that I'm all for charter schools. I think there's a lot that we could do to improve whatever form public school choice takes, but I think the direction that we have been moving is not the right one.
So we'll table religious for a minute, just because I think that could suck up everything in this topic. And Neil, he mentions accountability as an issue that is a concern with these programs, and I'm just curious what your thoughts would be about accountability in the private school programs or in public schools in general?
Yeah, so I think the quality control issue is a very common one, the concern, and I think it's very understandable where people think, well, how does a parent know what is a good school? The first thing I'd say, though, is I step back a little. So, for instance, you use the term we as taxpayers, but we don't have like one mind. And so I try to abstract from or move from we to we don't actually know. There's not like consensus on everything that's good for kids. There's not consensus on what it is that is most important for education. So my first response is we don't want to have one answer for what's good in education. Is it test scores? Is it completion of college? Is it formation of morals? Things like that. So I totally agree that quality is a big concern, but it gets difficult once you say, well, who is going to define what quality is? Because we have so many different things that we value. But I think that we also may understate the ability of parents to do some discerning of what quality is. So first, you would have some idea of what it is you want from a school, and I will put religion back in it, but just not to cause trouble, but because it's important. Your first thing might be, oh, I want a school that teaches values that are consistent with my own. And that's already a quality issue. You're saying this school does that. And you can talk to people who go to that school. Often we get information from neighbors, open houses. I know that you can choose a school that sometimes if it's a religious school, it's attached to your church, so you know a lot about it. And I think that private schools tend to use outside tests, and parents will ask for outside tests to get some assessment of where their kids are relative to kids outside the school. So, for instance, I think many Catholic schools and other private schools use Scantron tests or Iowa tests. So you get this sort of nationally norm-referenced assessment of, yes, I'm getting grades from my child's school, but I can also see where my kids are relative to others. So I don't think we have a sort of vacuum of quality indicators just because we don't mandate them from above, although of course a lot of school choice programs do say, well, you have to at least give a nationally norm reference test, which generally speaking I don't get the sense that most school choice supporters get very angry about. Probably there are some. So I just don't want to, I think we may worry too much that there is no quality control in private schooling or school choice, because there is. And the flip side is it's dangerous, I think, to have government say, this is the measure of quality, not all these other things that people may care about.
Michael, where do you see the balance between parental freedom and choice and these accountability issues?
Sure, I think I largely agree with Neil on this, not surprisingly. When we at IJ review legislation, we're not so much concerned with the policy choices of what line is the right line in terms of the government ensuring accountability in these programs, what testing should or should not be required, what regulations the government can or cannot impose on participating providers. We're really looking at these in terms of, are the programs legally defensible in court? Because that's what, we're not going out to create these programs. We're reviewing them to ensure they're legally defensible and defending them in court. So I'm looking at this more as not from the kind of policy perspective of what the right lines to draw is, but I agree with Neil that I think very few folks in the pro-school choice movement would have any heartburn with the types of modest assurances that are written into most of these programs to ensure that schools are held accountable in some regard. I also agree that we can't capture the measures through testing and other such mechanisms to capture what concerns really drive many parents in wanting these options for their kids. One of the biggest motivating factors for parents to choose to participate in these programs and to choose the specific schools that they do under these programs is safety. Particularly in urban areas and inner city areas, parents are terrified of what is happening or might happen to their kids at the public school to which the government has assigned them. They want their kid to come home at the end of the day, and that many times is the biggest motivating factor for parents to choose to participate in these programs and to choose the specific schools they do. I don't know how you account for that, or through regulation. I think it's the parent that ultimately is the one that is taking those things into consideration, and I don't see a need for the government to be too heavy-handed on this issue. One thing I did have a question though on is this idea that school choice arose after kind of the charter movement, after it kind of had fractured, right? That the progressives started kind of backing off of charters, and then the conservatives and libertarians took over the movement to push kind of private school choice. I don't think that's true for a couple of reasons. Number one, the charter and modern private school choice movement are contemporaneous. Like within 2 years, you have the nation's first charter law and the first private school voucher law in Minnesota on the charter end, and Wisconsin on the voucher end. And in both cases, including the private school choice movement, it was progressive legislators and advocates who were the biggest champions of the private school choice program. So I'm thinking Polly Williams and Howard Fuller in Wisconsin, Fannie Lewis in Cleveland with the Cleveland tuition program, Kevin Chavis and Virginia Walden Ford and Mayor Anthony Williams with the District of Columbia Opportunity Scholarship Program. These were black legislators. I can't speak for them whether they would self-describe as progressive, but I think they would. These were the biggest champions of the early voucher programs, and in many cases, they advocates and legislators of their ideological stripe continue to be the biggest champions of choice. So I think this is I don't necessarily agree with your kind of historical accounting that it was the conservatives and libertarians who kind of, took us in the direction we are now as progressives backed off the charter movement.
So I would say they started contemporaneously, but if you look at where the energy was from the period from really the mid-1990s until maybe a decade ago, I would argue the energy was largely in the charter movement and in sort of public school choice, because that's where you could find something resembling a 50-state strategy for some kind of choice program. It is absolutely true that civil rights groups were important in building some of those early school choice policies. And when I say school choice, I'm not just talking about private school choice, but whatever form that may take. I think it is a very open question whether those groups are going to go along for the ride with these new programs that, again, are just set up in ways where they're shifting resources from relatively impoverished areas to much wealthier areas. And I think that just violates the goals and the spirit that motivated a lot of those groups to join that coalition in those early days.
Can I just say something I forgot to say? Because when we talk about quality, it's not, I think, just about what are the outcomes we're looking at, but it's actually important, and I should have mentioned this, that parents actually know how to navigate these new systems and how we get information to them. And Colleen's been doing a lot of work on that, because I actually do think that we've had this sort of explosion of universal school choice programs. And even I was sort of caught or I was on my back foot when all of a sudden a whole bunch of them showed up. And I think we got the policies, but haven't had the time to put together a lot of the infrastructure that parents need to be able to navigate them. And so if you want to talk about that, feel free, because actually that's a really important quality question that I should have remembered right off the bat.
Well, and I think there's a lot of similarities between the explosion of educational freedom and kind of any disruption where, sure, in the early stages, the well-connected, the well-off always benefit, but now we all have iPhones in our pockets, So I see educational freedom being similarly in some areas. Of course, existing private school families are going to be the first ones to use these programs because they're already in that system. So if they can take advantage of it, of course they will. But as these programs grow, more people learn about them, more options open, And eventually it will benefit those communities that you're thinking of. And it's, along with the navigation issue, as these programs grow, as people become more familiar with them, the navigation support arises, and it's just naturally going to happen that it expands to those areas. So I think it's easy to look now and say, oh, this is a concern, but flat screen TVs, nice cars, cell phones, I mean, in every single area of life, as these, as innovation spreads, it starts out with the wealthy and ends up benefiting all of us.
So I think that's one scenario that could play out. I'll give you another one. And this is the story that people who study Chile will tell about what happened with Chilean school reforms that are probably more similar to what we're doing here than anything else I've seen. In Chile, they were providing vouchers. Those vouchers didn't cover the full cost of attendance in a lot of schools. And so what happens if you give people some money to attend private schools, but it's not enough to actually pay for the school? Well, it's people who can cover the difference who are going to attend those private schools. And it's people who have private schools around. And what ended up happening in Chile is you got a terribly stratified school system where you had the haves in the private sector and the have-nots in the public sector, which maybe to some extent we have sort of here, but with private schools, roughly 10% of school enrollment or whatever it is not the fundamental feature of our education system. That absolutely could be the case.
I mean, it kind of is in our public system.
Say more?
That is our public system today, where the wealthy districts have these elaborate, beautiful schools, and the poor districts have terrible, unsafe schools that people want to leave.
So, I mean, obviously, I'm obviously concerned about inequalities within the public sector too, but if we're talking about taking families with wealth, essentially removing them from the public sector and putting them in the private sector, that is not going to be good for those schools that I think we're both probably concerned about, those public schools that are lacking for resources now. That problem gets a lot worse. And I will say, in response to something Neil said that I agree with very, very much, that I think is a really important point on school choice, is I think we have, if there's one thing that we really have missed when it comes to school choice policy, it is that we underappreciate the number of barriers that get in the way of families when they're choosing schools. And I think we have confused the ability to request schools with the ability to actually choose and enroll in schools. And there's a lot to say about this, but it's everything from transportation barriers to school location. So if you're living in poverty, you don't have great options nearby, and all of the sort of fancier top schools that you can choose locate across town, well, that's not going to do you a whole lot of good. And then add to that information barriers, add to that enrollment processes, or schools not being so welcoming of some families. And if the school, I think, and there's always time to get better with this kind of thing, but if the school choice reform movement had taken more seriously those barriers, I think it would be in a different place right now.
Would you levy the same criticisms, though, with the public system, like in terms of residential assignment? I mean, to me, that's the greatest source of discrimination in education, is relegating a child to a school based on nothing more than their home address. So what about school choice in the traditional public school context? Are you more open to that than to private choice options?
I did, and as I said at the beginning, I am not at all a school choice opponent. I do think that families should have choice, and I worry very much about assigning kids to schools and then what that means for the families that just realistically do not have the option to go and pick a different place to live if that's what they want to do. That I absolutely will sign on to that. What is important to me is that the schools that they're choosing into have the kind of protections and guardrails and quality control and accountability and transparency that I think we can reasonably ask of public schools. And I take the point about we the taxpayers, we as society don't necessarily believe the same things. But at the same time, I think there's enough agreement about basics. Like when we're spending public money on schools, we should have some sense of what they're doing and what that money is being spent on. So I do think there are the private interest schools, there are public interest schools, and we can talk about both.
I'll just add that, so I think that, for instance, access, transportation, things like that are very real barriers. But at least from what I've seen, people within the school choice movement are actually talking a lot about, well, how do we overcome these things? How do we change policy so that those kinds of barriers to access are reduced? So, but again, I do think, and I think this may have been sort of the historical point, was We did go from a period for a very long time when most school choice programs were small and tended to be targeted to people who were low income or assigned to poorly performing public schools to a universal choice in lots of states. And there were good reasons for that. I think everybody should. The norm should be choice, that money follows the kids, and that we saw that smaller programs tended to be easier to eliminate. They didn't have a lot of people with wherewithal to sort of fight for them, to help guide, to make them better. And so there were reasons that I think we went to universal choice and it was good, but it did happen very fast. And I think we are definitely, school choice people are looking a lot more now at, well, how do we make them work for people? And part of that is you have to have the programs in order to learn the problems that they have. And again, Colleen's been doing work on helping people navigate. We've been talking about transportation. So the concerns you have are very real. And I would say that people who are supporters of school choice recognize that and are working on those problems.
I'm a little bit late going to audience questions, so are there any here in the room? I've got some online in the meantime. There should be a microphone coming to you. Oh, the microphone. Oh, sorry, I didn't see it. If you could just tell us, your name and where you're from.
Will Estrada, Senior Counsel, Homeschool Legal Defense. I'm old enough to remember when conservatives were all saying charter schools were going to save education. And so the question, that didn't really turn out the way everyone hoped. So the question is, how do we keep that from happening with ESAs?
Keep what with happening, sorry?
They fail to achieve the educational success that everyone, I think, right now is hoping that they'll achieve.
So I think they will fail to achieve the success that everyone might be hoping they'll achieve. On the charter school point, and I think this is an important part of the charter school story, and will be too for ESAs and for tax credit scholarship programs. These reforms don't happen in a vacuum. They happen in the context of whatever else is going on in schools, in society, and policy. And I would argue that when we look at charter schools and the way that charter schools, the kind of charter school movement unfolded and what kind of outcomes we got from charters, the single most defining thing is that it happened at the same time as the test-based accountability movement. And so you had charter schools which were sort of premised on the idea that you would have, you let 1,000 flowers bloom. These schools are going to do really cool, innovative stuff, and then families are going to pick schools that are doing different kind of things. Well, at the same time that we did that, we had a very rigid test-based accountability structure that charters were accountable to. I think too rigid. At the same time, I do think there's a role for testing, but that's a different conversation. But I think what ended up happening with the charter sector is we did see innovation, but it was innovation in the in service of trying to get the best test scores you could, because we had imposed this sort of second set of requirements in form of accountability on those schools. So I think the charter story is actually quite complicated. I think it's an interesting thought experiment to ask what would the charter movement have looked like had we not had test-based accountability at the same time. My suspicion is it would have played out very differently. But I'm not the person to ask for how the ESA, how ESAs will unfold well, because I do not think they will.
I would just say for ESAs, charter schools, what does Finland do that's so great? Everything we ever hear in education policy that this is what everyone should do, we should be modest about all of that. There are no panaceas. And I think we should say that about everything. ESAs are not going to solve every problem. They are part, I think, of improving an education system that has insufficient choice and insufficient parent power, but it doesn't make everybody use the science of reading, if that's the best way for all kids to learn to read. It doesn't require moral values to be taught in schools if we think that's most important. It is a policy, it's a mechanism that improves what we have, but it doesn't cure all ills. And we have to say that really, I think, about everything we do in public policy.
Yeah, I don't think there's a silver bullet. ESAs are not the silver bullet. Charters weren't. My definition of success is ensuring that the needs of children are met, right? Children are unique individuals. They have unique educational needs. Even the best public school, private school in the country isn't going to be the best school for every child. I want to ensure that we have a variety of programs that provide access to parents and children so that they can get the education that will best meet their individual needs. And I see ESAs going a long way toward doing that. but I certainly see a continuing role for charters, for traditional public schools. I want all of these options because I don't think that any single type of program can meet the unique needs of all children.
That was a good segue for an online question we have, which is how does school choice support alternative scheduling such as hybrid, 4-day, or non-traditional hours school options?
So this goes to some of the stuff I was talking about in the second point I made about Meyer and Pierce going forward, being used to protect the rights of education providers. I think right now, a lot of these new innovations, like I said earlier, don't fit well into the current regulatory schemes we have, and you often see government trying to kind of force them into one category or another. ESAs in particular are making it possible for more parents to kind of demand these options and providers in turn to provide these services. And it's unquestionably resulted in this kind of explosion in innovation. What is interesting to me, though, is going to be the government response to that, whether we will, whether through good policy decisions or through litigation, ensure that the government doesn't thwart these innovations that are made possible by ESAs, or are we going to see what government tends to do, right? The government's going to government, the government's going to regulate, and I hope that as we continue to provide greater flexibility through ESAs and similar programs, that we can ensure that government doesn't stifle and thwart the opportunity through either applying old regulations that don't fit or new regulations that are specifically designed to preserve the old system of traditional private school, traditional public school, homeschooling.
Before you guys, if anybody else wants to, but if you have a question, maybe raise your hand, and while the microphone gets there, I was just curious, John, do you have any thoughts on not the school choice impact of it so much, but just the idea of these different types of like hybrid, shorter work school days, things like that?
So, I mean, I'm open to families having those types of choices for sure. I think there is some room to do that within a kind of public school framework where, again, you have the guardrails and protections there. I do agree, like something like a 4-day school week is maybe a separate conversation, but I do have some concerns about 4-day school weeks. I think though, like if a family, I mean, I should say too, I have no objection to the idea of a family paying for private school, or even in some circumstances getting some public money to pay for private school because they want a 4-day week or some kind of hybrid schedule or some kind of micro school. It's not a principled objection to that idea per se, but I do actually think there's more room for that within school districts and within school district frameworks than we have explored fully so far.
Hi, Luke Moore, Americans for Prosperity policy team. My question is this. So we've talked a lot about quality control and the concerns. Is there a sense that the parents' decision-making process, the trial and error of maybe sending their kid to a school, deciding that school is not the right fit, pulling them out, transferring schools or something like that, makes the parent the quality control expert? Or would that be, I don't know, would that be different from what I'm saying here?
Yeah, thanks, Luke. So the way I think about it is that I think a lot of these choice programs are implicitly relying on parents as their quality control mechanism. So that parent who tries out a new school, and maybe you don't have a whole lot of information about that school you choose, because that is an important point too about testing, is in the scenario I talked about with my kids who are in a public school, a magnet program in a public school, I at least can see something on state tests, and there's like some apples to apples data that I can use to see how one school is doing on those measures relative to other schools. In this environment where you have schools that may not administer any test, or they may be required to administer a test but not required to report it to anyone, which is something that a lot of states do, you really have no idea. And so if you're a parent and you go and you pick a school and you might do your best to get a school that you think is going to fit your kid well, and for reasons that are beyond your control because it's hard, it doesn't work out, and then you say, okay, time to switch schools. Implicit in this model is that is where quality control lies, and that is where accountability lies. That the schools that are good are going to retain those kids. The schools that aren't are going to lose those kids. Maybe they close. And I'm just very skeptical, both that is an effective quality control mechanism, and second, that it's an efficient one.
How often, though, do we see underperforming public schools close, though? I mean, I think implicit in the private school choice model is if the school's not providing an adequate service, parents won't choose to go there, and I think the schools will close, and we have seen that. How often do we see public schools shut down because of what a poor job they're doing in serving the kids that are assigned to those schools?
So I'm arguing for different quality control mechanisms. Like, I do think even if you have these kinds of universal choice programs, we should be requiring them to administer tests. And I think actually private schools have a fair gripe in some cases where if they administer the state tests but their curriculum's not quite aligned with the state content standards, like there are reasons why you might not expect to see great test scores on those tests. But we need to see how they're doing. We need to see how they're doing on those tests. If they want to administer a different test, make the case for it, or maybe you administer both. But I am of the view that we private, public, whatever it may be, I don't think that parents exit should be our only quality control mechanism.
Yeah, I would say that it's not just the ability of a particular family to exit. It's that you can also find out how many families, or is there a tendency of families to exit that were there before you ever got there? Some of that is because you may know the school and you may be familiar with your community and you know that there were people who went there and they left, and you may even know them as neighbors and they'd say, that school just didn't teach well, or the hallways were chaotic, or something like that. I think that's probably how a lot of this is done. And then we have, as we've had more school choice and expansion of websites like Niche and others, where people will put their review of the school. Now, yes, some of that's self-selected, but you can start to see the balance. So you can learn a lot about a school without having the government mandate it. I think you learn a great deal regardless of the test scores. And the other thing I'd say is, so if a school gives you their average test scores, that doesn't tell you a whole lot about a whole lot of people who may not be at that average, a whole lot of different types of kids who that school may not be serving, and you could almost give an unfair, like overly rosy assessment of a school just by saying this is our average, by not knowing how it works for all sorts of different kinds of kids. So I think that test scores are not nearly enough, but what parents can learn actually is very powerful.
And I think that's our time, right? Unless the schedule changed.
I think we have 4 more minutes because
Okay.
we're a little off. I bet we could do one more question.
Okay, one more question then.
Yeah, hello, I'm Callie Chaplow. I'm the Director of Government Affairs for Home Educators Association of Virginia. And I wanted to ask you guys a little bit more about understanding your position on ESAs, because we've seen with government involvement in the financing of higher education, both through the subsidies directly to the schools and to the loan programs, we've seen the quality of education and the quality of education go down and the cost go up. So how do we prevent a similar correlation when we start sending the money through the ESA programs?
I think ESAs are, by design, help combat the sort of things we've seen in subsidizing higher ed tuition because they can be used for things other than tuition, right? It's not as if you get a check, you pick the school, and it goes to the school. The school, in turn, has every incentive to jack up the tuition to match the voucher or otherwise. ESAs allow parents to exercise a lot of creativity and purchase individual courses from schools, or decide that the flexibility built into them, I think, prevents the type of price inflation that we've seen by subsidizing higher education through student loans. Jason Bedrick at Heritage has also studied the tuition increases over time in states, in private school tuition increases over time in states with and without school choice. And obviously tuition goes up over time, that's just a factor of inflation, but the tuition increases over time have been less for private schools in states with educational choice programs than in states without. So I think there's, the empirical research that I'm aware of actually shows that tuition increases at a lower rate in states with robust choice programs.
Oh, I was just going to say, I'm worried about that as well. I mean, I talk about higher ed too, and I'm always worried about price inflation. And I do worry that there will always be upward pressure to say we need to have more money into these. But as I've worried about that, some people have occasionally talked me down from the ledge and noticed that the barriers to entry to create a new K through 12 school are way lower than higher ed. So you'll have much more of a supply response probably to school choice that will have downward pressure on price. And that made me a little bit more comfortable. Not entirely, because I do think there will always be this upward pressure saying, well, we need to spend more, so you need to increase the ESA, but that's a problem. When it comes to when we say in higher ed, people are learning less, I'm not sure it's a case that on any given school they're learning less. It's that we have put pressure largely through student aid for more and more people to pursue degrees, which means that employers are more and more likely to require degrees, even if the job hasn't actually changed, and that creates a credential treadmill. But we wouldn't really see that in K through 12 because we have compulsory education laws that say everybody has to go anyway. So I think in higher ed, a lot what we saw was people who might have done something else, not pursued a four-year college degree, may have done some CTE or something like that. They feel this pressure they have to go to higher ed that we all have to go through K through 12, so you can't push any more people into it.
And on the program design, a really simple way to guard against it is rollover. So if you can roll over your funds year to year and use them for costs down the road, including higher education, career technical education after high school, I think that's the best way to guard against it, because then parents have an incentive to shop around. And I do think we are out of time for real now, so. Thank you, everybody, for coming. Thank you to the audience. I apologize if I neglected this side of the auditorium. I blame the light there.
All right. Good morning, everyone, and thank you for joining us here at the Cato Institute for today's continued conversation on parental rights. I'm Jordan Brewer, and I'll be moderating today's discussion. We're honored to be joined by two leading voices on this issue, Congressman Virginia Foxx. She represents North Carolina's 5th District and has served as both chairman and ranking member of the House Committee on Education and the Workforce for a combined 8 years. She's a longtime advocate of education freedom, parental rights, and federalism in education policy. And she's famously a stickler for word use and the meaning of words. One example, she's no fan of the word training. She has famously said, "You train animals, you educate people." Well, as we talked about last night at dinner, Neil's a former artilleryman in the Army. I'm a current Army Reserve officer. We've done a lot of training, so either they're not listening to you, ma'am, or they do think we are dogs. So, Neil McCluskey is the director of Center for Educational Freedom here at Cato. He's one of the nation's foremost scholars on school choice, constitutional education issues, and even dabbles in name, image, and likeness policy for college athletes. So his research spans into a lot of different areas in education. So together we're going to be exploring the legal and political landscape around parental rights, what they mean, why they matter, and what's at stake. So let's start off with you, Congresswoman. We'll just start off with a very broad question. What does parental rights mean to you, particularly in the context of education?
Well, it's the ability of parents who have the God-given right to direct the upbringing and education of their children. I think it's pretty simple. Without interference of any entity, particularly the federal government in our case.
Yes, ma'am. Do you have anything to add?
Yeah, I look at it slightly differently. It's in particular as opposed to government. So we are typically talking about who makes decisions for kids. I think that first and foremost is parents, not government. So when we talk about parental rights, it's really in saying they're the ones who should make the decision, not government that often tries to override those decisions.
Absolutely.
So I guess, and you know, listening to our earlier panels, it seems like a lot of the tension here is between parental rights, children's rights, and the obligation of the state government, the federal government, local government's involvement in ensuring those different rights and those tensions. How do you, as a congressman, try to work out those tensions?
Well, I think we first have to make the assumption that most parents are good and loving people. There are some that are not. And in that case, the community/government has a role to play to protect innocent children who may be abused by their parents. But for the most part, we have to assume that the way we were formed again by God is to have families, to have children, and you know that old saying about don't mess with a mama bear, because mama bears have very, very strong feelings about their children. And I want to say I see an extremely healthy thing happening in our culture where men are taking a much more strong interest in the rearing of their children. But I think the only role that the government has in the upbringing of our children is to protect any children who might be abused by their parents. And we know that there are some. But I think the nature of parents is to protect your children and want the best for them. We know over the years that if you do any kind of polling, the first thing parents say is they want a better life for their children. And the way for a better life is generally a good education. So we see that over the years.
Yes, ma'am. And Neil, I think, like, you know, earlier panel, we talked about the devil's in the details on this, right? What is abuse, and how do you define it, and who defines it? How do you kind of fix that issue?
Yeah, well, I'd say first, and I think the first panel talked about it, you really do have to take it on a case-by-case basis, because it's not always just a clear line of what is or is not abuse. I do want to echo something before I answer your question, so classic, I'm going to dodge it. But when you mentioned mama bears, I think that's really actually important, and I said it in a much less impactful way in my introductory remarks, which is the science actually shows that parents, in their brains, I mean, chemically are committed to their children. So this isn't just something we say. I mean, it's really something that's established. But you're right that there will be I think a very small subset of parents who are neglectful or abusive. And I really do think you have to take that on a case-by-case basis. And I think the way that is right to deal with it is how we typically deal with things in our criminal justice system, which is if someone suspects a child is being abused or neglected, they report it to authorities, there's an investigation, if there's sufficient evidence, charges are brought, and then it's dealt with in a court of law in which parents can defend themselves. And then if they lose, then government has a role in intervening. But we have to give them all those protections that we give anybody who is accused of doing something wrong to somebody else, especially if the government's going to step in.
Sure. So moving to some legislation that you've introduced, in the Family Rights and Responsibility Act, which you introduced with Senator Tim Scott being the Senate companion, who's also my former boss. Could you walk through us the kind of the key provisions of the bill and what concerns or trends motivated its introduction? And just for the audience, kind of a general sum up of this bill is the purpose is to protect the right of parents to direct the upbringing of their children as a fundamental right.
Right. You know, it's really a pretty elegant bill. And the reason I say that, it's 10 pages long. And it is very clear about what it says. You named the first thing. The second is prevent the federal government from substantially burdening the fundamental right of parents without first passing the strict scrutiny test. So that's a second piece of it. And the third is allows parents to raise a violation of the act as a claim or defense in judicial or administrative proceedings at the federal and state levels. Now, I'm not an attorney, but again, I think the way this bill is drafted, and in the panel just before us, which I had a chance to see most of, I didn't see it all, they talked a lot about the cases that had come before us, and it goes all the way back to the case in 22 with the sisters, and it outlines several cases that established the precedent for this piece of legislation. So I think it's really, really well defined, and again, a pretty elegant bill in terms of how a lot of legislation is written.
Yeah, I think it's very important that the federal government not be able to intervene on what parents are doing in education and otherwise. If you read about sort of the formation of the federal government, like James Madison said, actually almost everything the federal government's supposed to do is external. It's dealing with other countries, it's dealing with trade. It's not internal. That's what's reserved to the states. And so I think that it's very important that we continue to focus on states and local governments, but most importantly, empowering families to make decisions for themselves.
Excuse me, George, but I should have said this at the very beginning, I guess, although I think it's implied here, is I obviously think the federal government has no role in education. Mm-hmm. And when I go out and speak to groups, I hold up my pocket copy of the Constitution, which I meant to bring with me and forgot, and I say, okay, you will not find the word education in here. So there is no role for the federal government. And as you alluded to again, Neil, in the 10th Amendment, it says, if we didn't outline it for the federal government to do, then it's up to the states and the people. And so I think it's very important. And I think one of the most insidiously bad things that's happened in this country, if I'm not duplicating myself, it is that we allowed the federal government to take control of education in our country. And unwinding it, I think, is something we very desperately need to do.
And on the constitutional pocket, we have a lot of those. We can send you the box if you need them. This is actually a good segue to the Parental Bill of Rights because, as you said, you believe there's no federal role in education. But the Parents Bill of Rights creates federal protections for parents. So how do you kind of work out the tensions of having a piece of legislation that you've co-sponsored that requires things of schools from the federal level, but also you believe that there should be no federal role in education?
Well, at the time we introduced and passed that bill, we had a president who very much believed in the role of the federal government. And so the goal was to respond to the movement in this country, pardon me, where parents were beginning to say, we have a role here and we want to assert the role. And so we had a Department of Education. We still have a Department of Education, although we are, I believe, in the midst of tearing it down. And so as long as the federal government has a role in education, then I think it is up to us to give parents as much control as we possibly can. And the elements of the Parents' Bill of Rights does that. It forces transparency, and it forces the ability of parents to see what's happening and to make some decisions. Again, the previous panel talked a lot about that, and I happen to think because parents do love their children and because there's inherent humanity in most of them, they are going to make the best decisions they can for the education of their children, given lots of limits that they have. I mean, we all have limits in every part of our lives, unless you, I guess, Elon Musk, I mean, even he has some limits. He's found that out. But parents will do the best that they can with what they have to work with. I come from a very, very poor family. My mother had a 6th grade education, my father a 9th grade education, but they understood the value of an education. And particularly my father emphasized reading. And so I found my parents, again, within the confines of their lives, they pushed what they knew to do for me. I mean, we didn't have school choice when I was growing up, so I think parents will do that.
Yeah. I wish I had Elon Musk level limitations. But, and I think first and foremost that you're right, that the emphasis now in particular needs to be, always should be, but eliminating the federal role in education. But at a time when there was a lot of federal, and the federal government through previous administrations was pushing a lot of bad things, I think it's very important that the statement be made, at the very least, that it's parents who should be ultimately in charge of education. There may be balances to that, again, it's abuse or neglect, but definitely not the federal government. So I think that it was well timed to have the Bill of Rights at that time. My own personal predilection would have been, well, I really like the message, but I still wouldn't want it to come from the federal government. But given what the federal government was doing, it was clearly valuable to say, no, this is not what it should be doing.
But there was a real value in our doing the Parents' Bill of Rights because states took it as a model. And now a lot of states have adopted the Parents' Bill of Rights at the state level. So it shows that it did make a difference, even if we believe there's no role for the federal government because it's been adopted. I think the state of North Carolina adopted it almost verbatim, and a lot of other states have adopted it. So the states are seeing the push from the parents also, which is a very, very good thing.
Yeah.
So I guess another federal responsibility in education is Title IX. So with Title IX, it's dollars that go to schools to make sure that women and men are getting equal opportunities to play sports. But the major controversy now is that there's a lot of transgender women doing well in women's sports, and it's created a lot of issues, obviously, in your space in Congress. What's kind of your general thoughts on that? Do you think Congress has a role in enforcing these definitions, or that's a more local decision? What's your general thoughts?
Okay, Jordan, I'm reverting to my language issue, okay? I got in trouble saying this at the Rules Committee one day, but I don't like the term transgender women because you cannot transition from one gender to another, one sex to another. Cannot do that. You're saying there are men competing in women's sports. And I think every time anybody said that, I'm going to correct them and say, what has been pushed in our culture is allowing men who pretend to be women to compete in women's sports because they know they have an advantage. So I think Title IX was very much abused. First, I want to give a real shout out to Betsy DeVos. When she was secretary, she spent a lot of time, she and her staff, in bringing Title IX up to date in terms of the rules and regulations. And unfortunately, it was difficult to get the new rules went into effect, but then they were ignored and the Biden administration wrote new rules, which never went into effect. So we have the Betsy DeVos rules and regulations for Title IX, and that's what should be done. But I'm totally opposed to those men who portray themselves as women participating in girls and women's sports, boys and girls. And it's very difficult to understand how the Democrat Party, who fought so hard for Title IX, to now want to just eviscerate it by doing this and take away the rights of women. Again, I'm a proud Republican. I've always fought for equal rights for women under the law, but I just don't understand how the Democrats have gone against everything they fought for so long.
I think this is a really difficult issue. And I think anytime you have a clash of values, it's a very difficult issue, and I think that's what we're seeing here. I think first and foremost, we need to understand that there are a lot of things the federal government shouldn't do, but it does have a civil rights enforcement job. I mean, it's part of the 14th Amendment. So we can't just say it's not something the federal government has the authority to be involved in. My concern with any kind of values clash like this is, okay, the federal government maybe can be involved, but isn't it better that we let civil society and free society work out these clash of values themselves? Because this is kind of a new issue. We're still working out what are the morals involved, what are the right relationships between people. And I think the Title IX difficulty is both sides, are arguing that they're being discriminated against. And it's hard to say, well, which is which? To me, the answer for this in education, again, is educational freedom. It's school choice. We don't want, ideally, government deciding who gets to decide who's playing sports. That ought to be parents. And if they want their children, I think it's right for them to be in sports leagues that their schools are in that either allow transgender kids or not to play in the league they think is consistent with their gender. That should be something that they decide, not that government decide. So we really, on values clashes just generally, public schooling and government control is terrible because there is no one clear decision, and you've got to let millions of people make millions of decisions to reach what they think is best for themselves and to see what arrangements work better than others.
Great answers, very interesting insights from both of you on that. So let's, we got a short amount of time with the Congresswoman, so let's head to Q&A now. We'll be taking questions from both online and the in-person audience. For those in person, please speak clearly and directly into the microphone, and please announce your name and affiliation. Also, we could ask the Congressman a variety of different questions, but let's try to stay focused on the themes of today, so parental rights and education. So let's start with someone in person. Please raise your hand, and we'll bring a microphone over to you. You can start over there if you want.
Hi, my name is Beatrice Marnay. I'm with ESSET and Child Exploitation Think Tank. You were speaking my favorite subject, the federal government and the states. When states start violating parents' rights because it incentivizes the removal and adoption of children, and they're circumventing laws like ICWA, UCCJEA, and just transporting kids across the country to other states to hide them from parents so that they can't get to court and fight with them and prove they are innocent from abuse or neglect. They need that federal government in federal courts to step in and basically be the mediator of the state and the parent when their civil rights are being violated. If they remove that, there's no place for them to go. There's no oversight. There's no accountability. So parents are losing their rights. And today, as we, look in Pierce and versus Sister, the child is not a creature for the state to determine the outcome of the child. So how, if we remove the federal government, how would a parent get oversight when their child is stuck in a system that's not broken, it's dirty, it's incentivized? How would they be able to get help?
I'm not really all that familiar with this issue because it doesn't sound like an education issue, but you may have a lot.
I think one response to that, because I get a lot of letters about people who are upset with the social services in their area, but that really is a state issue. And again, I'm not a lawyer, so I haven't studied this issue as to how the federal government gets involved when there's something very clearly at the state level. But most of the laws, as I understand it, on abuse of children are at the state level. Now, there are problems with social services, people overstepping their bounds, I think, at times, and charging families incorrectly. But I think that has to be handled at the state level, and there is a pretty aggressive court system at the state level that the parents can use.
Let's do another one in person before we do online. We got a hand over here.
I can't hear you, so you're going to have to.
Can you hear me now? Yeah.
Yes.
Okay. What is the solution to the judiciary overmastering the family and divorce and in issues that arise with children? When we look at when it is a state issue, and if we're going to look at it as a state issue, we have to have some kind of place for a family to go to, a husband or wife, a mother, a father, a grandparent, when the courts have overmastered, taken a child out of a safe home, or through a divorce, the decision's been made by self-serving attorneys who've seen how much money's involved and have had dinner with the judge the night before to make the decisions of how things are going to turn out. So in this bill you're talking about, is there some kind of oversight for this?
Well, again, as Neil said, you're talking about a different issue than education, I think. And so I don't know the answer to that at the state level, but I think we're talking about the parents having this right coming so that the federal government is not imposing on the parents' right to choose where the child should go to school.
Yeah, and it sounds like you're talking about a problem with the judiciary, right, first and foremost, and that's a little bit outside of where we are, but I do think that if you have judges who are overriding the decisions of parents in ways that are not clearly connected to abuse or neglect, that is a serious problem. I haven't researched it enough to know how deep a problem it is, and I can say, it may not be so big, it's at least hit my radar as somebody who reads a lot, at least, about kids. But it may be a big issue that should be addressed by people in particular who focus on judiciary or judicial issues.
I'm going to do one from online, but I'm going to kind of paraphrase it and make it easy. Basically, where do you think is the extent that parents have a right with medical decisions with their children in school, particularly around maybe like controversial examples like vaccinations?
Oh, I can remember a time when a school wouldn't allow a child to take its own medication that they brought to school. I mean, it literally happened with my own grandchild. Medication went with him to school, and they wouldn't let him take the medication. Now we have schools that are deciding, again, to give children all kinds of medication that would change their lives forever. We got into this very, very quickly in our culture again. It's wrong. Nothing should be done at the school level that parents are not aware of. It goes back to the issue of transparency. We should not allow that to be happening. And how we went so quickly from one style of operating to another one is just amazing to me. But absolutely, medical decisions, particularly those related to this gender changing or attempt to change gender, which you can't do, it's just wrong. Parents have to be informed on any decision related to anything affecting their child, but particularly when it comes to medication that could change their lives forever.
Yeah, I think there's no question, especially a government school that you don't opt into. So private school may have rules, and when you go to that private school, you accept these are their rules on all sorts of things, including medication. But a public school is a government school, and the government has no right to require your child to take things or prohibit them from taking things that you think are important just because they say, well, we're the government or we're the public school and we get to do it. Now, there is a limit. If there is something that may make your child an immediate danger to other children, then there is a role to say, well, you can't have them inflict harm on others. But I think that is very rarely the case when you talk about something like this.
Right.
Yeah, I was going to echo that's kind of like the libertarian principle of the non-aggressive principle, which you can't inflict harm on others. Congresswoman, do you think vaccinations ever kind of reach that point where you know, if you're not getting vaccinated, you're potentially inflicting harm on other students, so there should be an expectation that the kid get vaccinated?
I do think we have proven science that there are certain things that you need to take, certain vaccinations that you need to take for protections. I think that's important that we promote that. We're seeing a measles epidemic. Just before I came over here this morning, they were talking about a whooping cough epidemic in the country right now. My husband, we think, lost his hearing as a baby because of whooping cough. And one of my staffers recently got whooping cough. Shock in our office. An adult could get whooping cough even after having been vaccinated. But I do think there is a role for vaccinations. I know it's a big controversy right now, and I think it'll continue to be a controversy. I'm not sure we'll ever settle the science on this. For some people, I think it is settled for others.
Yeah, actually, because I was thinking of it one way, and then you made me think of another. But we talked about child rights, that we should be talking about child rights, not just parental rights. And the first vaccination question is, well, what's the right of the child to be protected from a disease or an illness that may do serious damage to them? And so I do think there could be a role for government saying you must get this vaccination for your child because otherwise they're at grave risk of getting terrible disease. But that's very hard to draw that line because we do have worries about what are side effects, how dangerous is this. But what I was thinking when you first asked the question was in the COVID context. And I think what we learned in COVID was, to me, the first 3 or so months I understood. Lots of people being very cautious because we didn't understand really anything about COVID. But soon after that, we started to gather the data that students, the kids, were in very low risk of getting COVID, that there were lots of ways to mitigate it. And at that point, we started to have public schools saying, no, you got to get vaccinated, you have to wear masks, you have to do all these things that were often far beyond what the information we were getting justified. And so at one point, you would say that the public schools were being reasonable, but after that, they weren't. But even then, you've got to balance concerns, including for teachers who aren't kids, who are older, who may have more threat from COVID, which again goes back to why school choice is so important. You want people who are different, who who weigh health and educational outcomes differently, accept different trade-offs, to be able to choose different things. And another lesson I think we had from COVID is we shouldn't have stymied school choice as long as we did, where some people could afford to go to those private schools that reopened and were good for their kids, but others just had no options.
All right, let's do another one in person. Tiffany?
Representative Fox, thank you so much for coming today and speaking. Speaking about COVID, we saw the incredible influence that teachers' unions have on our children's lives. Is there anything that we can do besides abolishing the Department of Education, which I think is a great first step, to limit the power and influence of teachers' unions in our country? And just to be clear, I love teachers, but union bosses lead to learning losses.
I agree with you completely. And I've always made it clear. I was on a school board for 12 years. I was in the legislature, involved in education, and I stay involved. I think most of our teachers do a great job, and I'm an extremely strong supporter of teachers. But I don't like union bosses who try to run the schools and who made horrible decisions during COVID in particular. It was the union bosses who kept the schools closed for their own purposes. And I think, obviously, school choice is an answer to what we do about union bosses. And I think that's why they fight so hard against school choice, is because they want to keep the power that they have over the education. It's a money issue and it's a power issue that they have. And the more that we can promote school choice, and Neil, I love your term, government schools. That's what they are. And we ought to say that more often than public schools. There was actually a great article in the Wall Street Journal a couple of years ago saying they're really not public schools because the public doesn't have a chance to influence them as much as it should because of the power of the government. And I noted a little bit ago, the woman in the other panel said she represented the home educators of Virginia. And to me, we've gotten away from using the term education and we use the word school and schooling too much. And I think there's a big distinction between schooling and education. And what we have in government schools is schooling. And I think there are failures in charter schools, there are failures in private schools, no question about it. Nobody's perfect. But I do think there's more of an emphasis on education than there is on schooling when you get out of government schools.
Yeah.
So this next one's going to be about tax scholarships. I think this is kind of another interesting tension between parental rights, children's rights, and then the involvement of government. And as you said, you don't think education should, or the federal government shouldn't have a role in education. But the Educational Choice for Children Act made it into the big, beautiful bill.
Yes.
And this would create a federal tax scholarship program. So it is a tax credit program at the federal level. It's just kind of like the Parental Bill of Rights, where it's like a practical, just a practical thing you have to do because of the nature of our environment? Or is this something that you do think fits the ideal of empowering parents?
Yeah. Again, as the previous panel talked about this a lot, about those parents with means and parents without means, and how do we do something to equalize? Well, we tax a lot in our country, and I do think that the ESA and the bill that we got passed in the portion of the bill of the big, beautiful bill that allows a tax credit. It's up to $5 billion. We limit it to $5 billion. The goal was to get $10 billion, but limit it to $5 billion. That does give back, or gives the opportunity for people to direct some of their tax money into these scholarship programs that will allow people to choose a school and get some scholarship help. I see that as no different from our giving tax breaks to giving money to nonprofits. This is just funneling it in a very specific program. And so I think I'm very personally supportive of it.
I guess I'm just such a hardliner on federal, the Constitution that I came out against it, but I think there was a very strong effort by school choice people who have supported it and who I almost always agree with, to try and make it constitutional and that it's not expending money, it's really somebody being able to keep their money, and that is an important aspect of tax credits, is it's not the government spending money, it's you're keeping it. But I still, because I have a one-track mind, which is everything the federal government does is wrong, it still concerns me because it uses the tax code, I think, still to incentivize or reward some behaviors. And I think that education's not in the Constitution, and that even includes using the tax code to do things within education. I think the tax code is there so that we can get revenue for the specific enumerated powers the federal government has. So I fall against it, although again, there are lots of school choice people, probably the majority, who like it, and they're good people, and school choice is great, so don't get me wrong. I love school choice. The other thing I worry a little bit about is federalism sort of exists for our protection, and that I don't want to be in a state that doesn't have school choice, but I want there to be the ability for some states not to have it, because maybe we see that school choice doesn't work. That's crazy talk, but maybe, or we see better ways to deliver it. So I would really like to states to be able to continue to do what they do. And this bypasses that a little by saying, well, if you don't have school choice in New York, by the way, New York, get yourself some school choice, regardless what the federal government does. But if you don't have it, then you now do, because the federal government, and I'm a little leery of even having that.
But Neil, again, on the previous panel, the issue was brought up finally, I thought, it took a long time, that we really don't have good accountability for the public schools. We just don't. If somebody said, have you ever seen a public school, a government school fail? No. We pay more attention to the failures of what's considered the other. And last night when we were talking, Tommy mentioned, I said, where did you go to school? And he said, well, I had a non-traditional upbringing. I was homeschooled. No, that's the tradition. The government schools are the non-tradition. And so again, back to our language, we have let the government take over the language, and we've made charter schools and private schools look like the other, when really that was the norm until the government realized it could get control of education and then control the culture.
Yeah, well, I think that's absolutely right. And even for the tax credit, I mean, the reality is the federal government is heavily involved in education. Correct. Almost none of it is for private school choice. So if it's going to be involved, there's certainly an argument of, well, at least have it do stuff that's not all about this system that we think, oh, government schooling, of course, is how you get education, when it shouldn't be, and long time, for most of our history, it wasn't. So I think all that context is really important. And again, a lot of school choice supporters are behind this and make those arguments, and they all have merit to them.
And Jordan, if I can make one more point, nobody has questioned that when it comes to post-secondary institutions. We've had that for a long, long time. The money follows the person, but we have never allowed that at the elementary and secondary level. Again, I think because of the unions. We've been allowing since the GI Bill people to take the grants from the federal government and go wherever they wanted to for post-secondary education, but we haven't done it in elementary and secondary.
It does make sense that we think it's okay in higher ed and not in K through 12, although secretly, not so secretly, I'd get rid of all those programs too, but
well,
I don't understand. Yes,
I would too, yeah.
But it's totally inconsistent to say, well, here it's fine and here it isn't.
Shameful that the federal government is inconsistent.
How could it have happened?
How could that have happened?
I always thought they were our betters.
Well, I know you have a hard stop at noon, so I wanted to give you just a minute or two to kind of say if there's anything you feel like we didn't cover. You have a folder and a lot of notes here. I want to make sure you say everything you wanted to say.
I didn't bring the big, beautiful bill, but I did bring HR 650 just in case anybody wanted a copy of it. I would just want to say I really appreciate being invited to come to this program. I admire the work of the Cato Institute, and so I very much appreciate you're all doing this and keeping these issues before the public as much as we possibly can, because it is, education choice is a big issue right now. The role of education in our culture is a huge issue right now. Again, I think it always has been, but I think we're trending in the right direction. And my goal is to keep us trending in the right direction and never going back to the way things have been for the last 4 or 5 years.
Thank you, Congressman. Thank you, Neil. Great insights in this talk today. For everybody in person, we'll be having a lunch after this, so make sure to follow up upstairs and continue to network with each other. But thanks again.
Thank you. Thanks, Jordan.
Yeah, this is great.
Great job.
Yeah, that's fun.
Thank you very much.
Oh.